and welcome on a Monday. Welcome to the drama-free true crime destination where I bring you no gimmicks, no drama, and no BS. Welcome to Bethea'S Byte Reloaded. I'm Ernest Bethea, the last outlaw. So good to have everybody aboard. And this is going to be a fully loaded edition because I have got so much to cover today. So, with that in mind, I'm going to go ahead and open things up with my opening statement. This past week, justice didn't whisper, it screamed. From courtrooms to crime scenes, from celebrity scandals to child survivors, we watched a system built to protect, instead struggle to keep pace with the violence it's meant to contain. The headlines came fast. Verdicts, arrests, dismissals, and denials. But beneath them, a deeper truth pulsed. Justice isn't a headline. It's a warning shot. We saw a baby left in a stranger's yard after her family was slaughtered. We saw a teacher stab a couple to death in front of their children. We saw killers walk free, celebrities dodge accountability, and victims reduced to footnotes. This isn't just a docket. It's a moral autopsy. Each case this past week is a mirror, reflecting not only just the crimes, but the cracks in our collective conscience. And if we're honest, some of those cracks are widening. So we begin not with answers, but with urgency. Not with closure, but with confrontation. Because if justice is still possible, it must be louder than the silence that follows each scream. That's my opening statement. Let's get down to business. Like I said, I've got a lot to cover. So we're going to start right now with the doctor who admittedly supplied Matthew Perry ketamine weeks before his death. A doctor who was a primary target in the sweeping investigation of actor Matthew Perry's overdose death pleaded guilty on last Wednesday, not this past Wednesday, but last Wednesday, to supplying the Friends star with ketamine despite knowing he was a struggling addict. Dr. Salvador Plasencia became the fourth of 5 people charged in connection with Perry's death to plead guilty. He and a woman prosecutors say was a major ketamine dealer faced the most serious charges after Perry was found dead in the hot tub of his Los Angeles home on October 28, 2023. Plasencia stood next to his lawyer and said guilty 4 times for 4 different counts before Judge Sherilyn Peace Garnett in federal court in Los Angeles. 43-year-old Plasencia have gone on trial in August until the doctor agreed last month to plead guilty to 4 counts of distribution of ketamine, according to the signed document filed in federal court in Los Angeles. The charges can carry up to 40 years in prison. He is likely to be sentenced to much less, but there is no guarantee in his agreement. He spoke only to answer the judge's questions. When asked if his lawyers had considered all the possibilities of pleas and sentencing in the case, Plasencia replied, "They've considered everything." Now, one of Matthew Perry's ketamine suppliers expresses regret. Dr. Plasencia is profoundly remorseful for the treatment decisions he made while providing ketamine to Matthew Perry, the doctor's attorney Deborah White said in an email statement after the hearing. He is fully accepting responsibility by pleading guilty to drug distribution. Dr. Plasencia intends to voluntarily surrender his medical license, acknowledging his failure to protect Mr. Perry, a patient who was especially vulnerable due to addiction. In exchange for the guilty pleas, prosecutors have agreed to drop 3 additional counts of distribution of ketamine and 2 counts of falsifying records. Prosecutors outlined the charges in court before the plea and said that he did not sell Perry the dose that killed the actor. They described and Placencia admitted that Perry froze up and his blood pressure spiked when the doctor gave him one injection. But Placencia still left more ketamine for Perry's assistant to inject. In court, Perry was referred to only as victim MP. Placencia acknowledged that he knew the actor was an addict when he charged him thousands of dollars and gave him ketamine, a drug primarily used as a surgical anesthetic. Placencia has been free on bond since shortly after his arrest in August, and will be allowed to remain free until his December 3rd sentencing. Defense lawyer Karen Goldstein assured the judge that he is not a flight risk, saying he was born and raised in the area and is one of the primary caretakers for his son, who is about 2 years old. Placencia has already turned over his license to prescribe controlled substances. He has been allowed to practice medicine in the past year, but he must inform patients of the charges before treating them. Goldstein told the judge he'll now surrender his medical license too. Placencia left the courthouse with his lawyers without speaking to reporters outside. Now, this case raises questions about at-home ketamine use. While Dr. Placencia was not treating Mr. Perry at the time of his death, his lawyer's statement says, he hopes this case serves as a warning to other medical professionals and leads to stricter oversight and clear protocols for the rapidly growing at-home ketamine industry in order to prevent future tragedies like this. The only remaining defendant who has not reached an agreement with the U.S. Attorney's Office is Yasveen Sangha, who prosecutors allege is a drug dealer known as the Ketamine Queen, and was the one who sold Perry the lethal dose. Her trial is scheduled to begin next month. She has pleaded not guilty. According to prosecutors and co-defendants who reached their own deals, Placencia illegally supplied Perry with a large amount of ketamine starting about a month before his death on October 28, 2023. According to a co-defendant, Placencia in a text message called the actor a moron who could be exploited for money. Perry's personal assistant, his friend, and another doctor all agreed to plead guilty last year in exchange for their cooperation as the government sought to make their case against larger targets, Placencia and Sangha. None have been sentenced yet. Perry was found dead by the assistant, Kenneth Imwaza. The medical examiner ruled that ketamine was the primary cause of death. The actor had been using the drug through his regular doctor in a legal but off-label treatment for depression, which has become increasingly common. Perry began seeking more ketamine than his doctor would give him. Placencia admitted in his plea agreement that another patient connected him with Perry, and that starting about a month before Perry's death, he illegally supplied the actor with 20 vials of ketamine totaling 100 milligrams of the drug, along with ketamine lozenges and syringes. He admitted to enlisting another doctor, Mark Chavez, to supply the drug for him, according to the court filings. I wonder how much this moron will pay, Placencia texts Chavez, according to Chavez's plea agreement. Perry struggled with addiction for years, dating back to his time on Friends, when he became one of the biggest stars of his generation as Chandler Bing. He also starred alongside Jennifer Aniston, Courtney Cox, Lisa Kudrow, Matt LeBlanc, and David Schwimmer for 10 seasons from 1994 to 2004 on NBC's mega hit. Now, only time will tell with that if that last person, that last supplier of ketamine, will actually plead guilty to what she's being charged with. I mean, if she's the biggest one on the totem pole, not the doctors, then there is a reason why they call her the Ketamine Queen. We'll see where that leads up, and when the story is detailed. Next on this huge docket, the prosecutors are going to reflect how they were able to convict Christopher Davis. Christopher Davis has yet to be sentenced for his in his murder case. This is how the prosecutors broke this down. Cases like it are rare, nobody cases. But the Florida State's Attorney's Office got a conviction without a crucial piece of evidence commonly seen in murder cases. Barry Shovelbach went missing from Cape Coral on July 19, 2023, after a trial featuring 40 witnesses and extensive circumstantial evidence. Christopher Davis, Shovelbach's then boyfriend, was convicted of the murder. Just trying to find justice for Barry has been a difficult almost 2 years, and our hearts have been very heavy, said Miguel Blanco, Barry's friend who testified during the trial. The case presented unique challenges for prosecutors Jennifer Justin and Andreas Gardiner, who had to build their case without the victim's remains. This is my first homicide that did not have a body involved, Justin said. Gardiner had previous experience with similar circumstances. I did a nobody case about 8 years ago, he said. That was one of the first cases that had never been presented to our homicide unit as far as a nobody case went. The prosecution team got involved shortly after Shovelbach's disappearance and developed a strategic approach to the case. We were hopeful that ultimately he would be found, But we were of the mindset, hey, even if we don't find him, we still need to go forward, Gardiner said. Their strategy focused on creating a comprehensive timeline of events. I always wanted to tell a story. I wanted to begin when was the last time anyone had seen or heard from Barry to the time we can confirm, Barry's deceased. Gardner said he's no longer with us, and that's why we ended with the cadaver dogs on the 31st of July. Prosecutors relied on both physical evidence and digital footprints to build their case. They presented evidence showing Davis purchased a tarp, duct tape, and chocolate milk the night of Shovelbach's disappearance. Days later, Davis brought a shovel and pickaxe in Clewiston, all while using Shovelbach's credit cards and SUV. I think you have a body in a homicide, whether you have a body in a homicide or not, you're looking at the totality of the circumstances, Justin said. You're looking at the facts, your witnesses, and what evidence you can present. The prosecution also utilized audio evidence to help jurors visualize the crime scene. During opening statements, Justin slammed her binder on the podium 3 times and said, "No, no." She said this signified the last words and sounds Shovelbach made before his death. To put somebody in the moment by either bringing a sound effect in or having them listen to an audio clip or seeing a video of somebody do it, they can actually put themselves there. Davis's team attempted to create reasonable doubt by discussing Shovelbach's medical history and suggesting he might have given Davis permission to use his credit cards. However, prosecutors maintained their case was structurally sound. In a nobody homicide case, it's akin to actually being a rope that has fibers, Gardner said. If a fiber breaks, the rope is still strong. It's not like a chain, so to speak. After just 2 hours of deliberation, the jury returned with a guilty verdict. When asked about potential plea deals that might have revealed the location of Shuttlebox remains, Gardner acknowledged. There were discussions that were had with regards to ultimately resolving the matter. The prosecutors consulted with Shuttlebox family about the possibility of a plea agreement. Ultimately, they said Barry would have wanted justice to be served and the person who did it held responsible. Despite the successful prosecution, the case has left a lasting impact on everyone involved. Gardner recalled a particularly moving moment from a family member after the verdict. You lifted a huge amount of weight off our shoulders. We woke up this morning feeling so much lighter. Justin said, as one of the witnesses put it, we are part of their tribe now. Shuttlebox loved ones continue to hope for closure. We will never give up that we will recover Barry's body one day, said Rosalie Felico, one of Barry's best friends. Davis has filed a notice of appeal for his conviction. He's in a South Carolina prison, finishing up another sentence for an unrelated case. All I can say is that it is highly, highly rare to get a conviction when the victim's body is nowhere to be found. So for this conviction to happen, that is huge. My props, my respect goes to Jennifer Justin and Gardner for the for scoring that conviction, because like I said, it is a rare thing for that to happen. So congratulations to the prosecution team. Next up, a judge rules that a child's interview cannot be used in the murder case against Brandon Banfield. No relation to News Nation's Ashley Banfield, hopefully. And I'm trying to be funny, but this is a serious case. We're in Fairfax, Virginia. A Northern Virginia Circuit Court ruled that a prosecutor's case against IRS agent charged with killing his wife and another man cannot include a recorded interview from the defendant's young daughter. Fairfax Circuit Court Chief Judge Penny Ascaret denied prosecutor's motion on the admissibility of the young child's conversation with a forensic interviewer about what she believed was happening the morning her mother was killed at her home. That child's father, Brendan Banfield, was later charged with aggravated murder in the February 2023 deaths of his wife Christine Banfield and Joe Ryan, a man who was invited to the house that day. Deputy Commonwealth's Attorney Eric Klingen argued that the child's interview should be admissible at trial because she's the victim of her father's alleged killing. The killings occurred while the child was in the Banfield's basement, authorities have said. In December, Banfield was indicted for child abuse and felony child cruelty in connection with the case. It's an act of abuse by her virtue of what her father did that morning, Klingen said in court. Meanwhile, John F. Carroll, who represents the father, argued in court that Banfield did not consent for his child to be interviewed by authorities at police headquarters. Ascaret sided with the defense, citing a statute that a child's interview would be admissible only if the child were being directly victimized by the parent. She acknowledged authorities later pressed child abuse-related charges. But she said those indictments were not the basis for officials' interview of Banfield's daughter that day. The interview doesn't fall within that statute, as Ascaret said. So basically, this is both a complex investigation and prosecution. The evidentiary hearing is one of a series of developments in the official's multifaceted investigation and prosecution of Christine Banfield and Ryan's killings. Carroll also moved for the court to rescind Banfield's indictment and remove Klingon, the lead prosecutor, from the case. In his arguments, Carroll ruled that Klingon guided Banfield's co-defendant in an interview, though Ascarat denied both motions. That co-defendant is Juliana Perez Magales. She was initially arrested and charged with second-degree murder in the case. At the time of the killings, Magales and Banfield informed authorities that they walked in on Ryan attacking Christine and both shot him with different weapons. Attorneys have said this much in court. But last year, Magales has pleaded guilty to manslaughter in what prosecutors have long described as a scheme led by Banfield and the au pair to frame Ryan in the stabbing of Christine Banfield. Ahead of her plea, Magales provided a proffer to officials and was interviewed by Klingon attorneys and have stated in court. Her proffer corroborated a catfishing theory that Ryan was lured to the home on a social media networking platform for people interested in sexual fetishes. She also corroborated the theory that Magales, who began working for the family in 2021, and Brandon Banfield had a romantic relationship that began before the killings, and that she helped the husband in his conspiracy to kill his wife. "I'm just so upset and heartbroken for doing this to Brandon," the au pair wrote to her mother from the Fairfax County Jail last October in a message, which has since been entered into court evidence. "I love him and he loves me too. I have no doubts, but it's the right thing to do. For you, I want to be with you again." Now there's a dispute that arises over the catfishing theory. Let me get myself comfortable here. Despite her proffer, a divide appears evident among officials over the catfishing theory. Brendan Miller, a digital forensic examiner with the police department, testified earlier this month that his analysis of forensic evidence suggested that Christine Banfield was seeking to have an affair with Ryan. Miller testified that his analysis was based on multiple devices, and he concluded that Christine Banfield had connected with Ryan through a social media networking platform for people interested in sexual fetishes and matched her with Ryan. His findings diverged from a theory held by other officials in the department. The messages Ryan had been receiving were actually from Brendan Banfield posing as his wife. Deputy Chief Patrick Bruce, who oversaw the department's major crimes bureau at the time, confirmed in testimony earlier this month that he said Miller would never be doing another digital forensics case in your major crimes bureau after he analyzed the evidence. Carroll, Banfield's attorney, argued that court officials were not adhering to proper investigative guidelines when building their case and backing Bruce's catfishing theory without the supporting facts. In a court filing, Carroll wrote that Bruce retired from the department after the hearing in which he had testified. He wrote in another motion that there is a willfulness in the lack of recognition of the science, stating that the digital forensics are facts and the Commonwealth chooses to ignore and disregard those facts. Now, if you're gonna bring the facts, you're gonna bring the facts. You can't just bring theories without the support. That's all there is to it. And that's what's going to be the difference between a guilty verdict and not. Next up, a mother pleads guilty to abuse before the trial, just moments before the trial starts, in regard to her son's death. Parents killing kids, kids killing parents. What in the world are we coming to? Let's go to Bartow, Florida. A Florida mother pleaded guilty to lesser charges moments before her murder trial was scheduled to begin. Alize Seymour was indicted on charges of first-degree murder, aggravated child abuse, aggravated manslaughter of a child, tampering with a witness, child abuse, and causing a minor to become delinquent or dependent following the death of her 6-year-old son, Anthony Ruse. Alize's husband, Trey, who was Ruse's stepfather, was also charged in the case. On July 28th, just as jury selection was about to begin, Alize proceeded guilty to 2 counts of aggravated child abuse. She was sentenced to 20 years in prison on each count, to be served concurrently. Okay. Okay, now I'm caught up. Just making sure I'm reading everything correctly. Police were initially called to Seymour's home on April 22nd, 2023 for a reported drowning. They found the child face down in the tub, but noted the bathroom had no electricity or natural light, and the doors to the bathroom had been locked. When Ruse was brought to the hospital, medical staff noticed he was covered in cigarette burns and had rectal bleeding. In court documents, investigators said they found evidence that Alize and Trey would keep Ruse locked in a cage for hours at a time. Six other children living in the house told investigators they were rewarded for beating Ruse and forcing him into the cage. Ruse's 10-year-old brother said he watched Trey drown the victim. Search warrants served on Trey and Alize's phones revealed images of Ruse in a cage and discussions about forcing him into the cage and abusing him. Hours before calling 911, Alize texts Trey, "I want to put him up for adoption." Trey pleaded guilty to second-degree murder, aggravated manslaughter of a child, child abuse, and causing a minor to become delinquent or dependent, and was sentenced to 30 years in prison. As part of the plea deal, Trey had agreed to testify against Alize at her trial. Okay. I'm gonna say this. I'm gonna say this as calm as I can, and then I'm gonna move on to the next story. Trey and Alize Seymour deserve to be right where they're at right now, in a cage. Honestly, I think they should be locked up for a lot longer than the 20 years Alize got and 30 years that Trey got. The only thing that's supposed to be locked up in cages is animals. And Trey and Alize Seymour are right where they belong. And that's all I got to say about that. Next up, there's a development in a case where a girlfriend is now arrested after the body of a missing man was found in the river. And guys, excuse me for that pause in the middle of the last story. I was making sure I was reading everything correctly, and it's early morning here in Salem, Oregon. So the words are being jumbled. Look like the words are being jumbled up, and I want to make sure I was reading everything carefully to you. Okay, next up we're going to Cleveland, Ohio, where an Ohio woman has been arrested for the death of her boyfriend, whose body was found in the Huron River months after he was reported missing. A grand jury indicted Diamond Vaden, age 32, on multiple charges including murder, gross abuse of a corpse in the death of George Cox Jr., also age 32. Cox was reported missing in November 2024. His family told investigators they last heard from him around October 19 during a wellness check at the home Cox shared with Vaden. Officers found an empty apartment with little to no furniture and what appeared to be blood on the floor. Authorities said the blood was later identified as belonging to Cox. Cox's body was found on May 15th by two kayakers on the Huron River. His remains were wrapped in a bedsheet and bound with rope. Investigators said the bedsheet matched sheets found in their apartment, while noting DNA evidence and phone records linked Vaden to the crime. Vaden was arrested July 21st at a home she shared with 41-year-old Emmanuel McQueen Jr. Authorities charged McQueen with a weapons charge. Cox's father released the following statement to Scripps News Cleveland following Vaden's arrest. On behalf of myself and George's entire family, we are grateful for the diligent effort. Detective Kevin Callahan, Cleveland Missing Person and Homicide Department, put into getting answers in regard to my son's death. So many people go missing, and you don't realize how many until you're affected by it. I personally thought that we would never recover George. We did. I personally thought we would never recover George, but we did, and it appears that justice will prevail. End quote. Vaden is being held on a $1 million bond, and her preliminary hearing was scheduled yesterday. No, excuse me, I take that back. It was scheduled Saturday. 32 years old, throwing her life away just like that, when all she could have done was just break up with the guy, leave him alone. That would be the end of it, right? One would think that. Next up, a mom is sentenced after admitting guilt in the death of her 8-year-old daughter. Again, what is this world coming to, guys? All right. Now, what you're about to hear is what I call justice being served, ladies and gentlemen. A Michigan mother was sentenced to up to 50 years in prison after pleading guilty to second-degree murder and child abuse in connection with the death of her 8-year-old daughter. 30-year-old Chelsea Duprin was initially charged in March 2024 after Wayne County officers found 8-year-old Lila Castle unresponsive. The officers had been dispatched to Duprin's home following reports of a child in distress. They reported finding Lila unresponsive in her bed, wearing a diaper. Prosecutor Aaron Wilmoth said the assault on Lila was brutal, as she noted the more than 200 autopsy photos showed there was not one spot from her head to toe that was not bruised or marked on the child. Judge Sharice Anderson agreed, saying that she found Lila was thoroughly tortured. Referencing the autopsy photos, Judge Anderson said they were the most horrific photos of an 8-year-old girl I've ever seen in my entire life. If she was horrific, she was unrecognizable, and it is unimaginable what Lila went through. It is unimaginable that she sat for 2 to 3 days in the condition she was in, and nobody thought it was prudent to give her proper medical attention she needed. Duprin's attorney, Tiffany Howell, conceded that her client did not seek medical attention for her daughter, but said that she did attempt to care for Lila's injuries. Duprin initially told police that she didn't call for help sooner because she believed Lila was improving. Is she kidding me? In court documents, officers described the little girl's condition as severe, noting that significant swelling to her face, neck, and head rendered her nearly unrecognizable. According to prosecutors, an autopsy revealed Lila died as a result of a massive blunt force trauma to the face and head. Officers responded that Duprin mentioned bad spirits during questioning and claimed that a woman had appeared out of nowhere. They also noted that Duprin's own hands appeared swollen and bruised. Duprin had offered a tearful statement at sentencing, describing Lila as the most perfect baby and saying, "I will never understand why this tragedy has become our reality." Duprin's boyfriend, who was present during the events leading to Lyra's death, was not charged. He acknowledged that he recognized the girl was in distress, for it was. I'm sorry, guys. I'm still caught. This one's got me kind of choked up. Let me start that back again. Duprin's boyfriend, who was present during the events of leading to Lyra's death, was not charged. He acknowledged that he recognized the girl was in distress, but felt it was Duprin's responsibility to take action. Judge Anderson sentenced Chelsea Duprin to 28 to 50 years in prison. My opinion? My opinion? She should have got longer than that. She should have got life. She beat and tortured that child to death. I don't know how many different ways I can say that. She beat and tortured that child to death. I'm at a loss for words, guys. I am. What is this world coming to with parents killing their children, especially those so young, still in the single digits, don't even have much of a chance to live? What could that child have possibly done for her to endure such pain and torture, leading to her demise? Next up, influencer Emily Kaiser's husband will not be charged in her son's drowning death. Well, that might be some good news for the Kaiser family. Maricopa County Attorney Rachel Mitchell announced that Brady Kaiser will not be charged in his son's drowning. Mitchell says he will not face charges because there is no reasonable likelihood of conviction. Earlier this month, Chandler Police Department submitted the case for review, where they recommended the father be charged with 1 count of child abuse. Officials say Brady was home alone with his 2 children when 3-year-old Trick Kaiser was found in the family's backyard on May 16th. He later died days later at the hospital. Surveillance video from outside the home showed how the drowning occurred and the actual timeline of events. In order to convict the person of this charge, the state has to prove beyond a reasonable doubt to a unanimous jury that the person failed to perceive a substantial and unjustifiable risk, and that failure to perceive that the risk was a gross deviation from standard of care a reasonable person would show. Every case submitted to the Maricopa County Attorney's Office is evaluated using the same standard, whether there is a reasonable likelihood of conviction or release stated. The Maricopa County Attorney's Office determined that the case did not meet the standard for charges. The Maricopa County Attorney's Office determined the case did not meet the standard for charges. MCAO's review of the case involved the attorneys assigned to it, along with highly experienced senior attorneys and the county attorney herself. Given a court order, no additional details can be discussed at this time. So, Brady Kaiser, his wife Emily, both should be breathing a sigh of relief right now. But still, there may be more questions than answers in that case as well. And this next article, I'll take a song from The Sound of Music, and it goes like this. So long, farewell, Vida Saint adieu to you, to you, to you and you and you. That's right. Another attorney has withdrawn from Sarah Boone's case. In case you need another laugh, I'll sing that lyric one more time. So long, farewell, Vida Saint adieu to you, to you, to you and you and you. It's a familiar situation for Sarah Boone. Another attorney has asked to be removed from her case. Boone is currently serving a life sentence for the murder of her boyfriend, Jorge Torres Jr., who died after being zipped up in a suitcase and beaten during a game of hide and seek in February 2020. While Boone has indicated she wants to appeal her conviction, she has been unable to. She has been able to unfile the necessary paperwork, in part because she has not been in contact with her attorney. Weeks after forming a formal inquiry, into the status of her appeal, her appointed attorney has asked to withdraw from the case. Joshua Adams has been representing Boone in her appeal since he was appointed on December 18, 2024, just weeks after Boone was sentenced. Adams was the second appellate attorney to represent Boone. The first attorney appointed to represent her in appeal, Alan Holland, was replaced just 16 days with no reason publicly given. In his motion to withdraw from the case, Adams said that he is, quote, no longer practicing appellate work or accepting court-appointed appellate cases, which would make continued representation a hardship. Boone complained about Adams' lack of response and her repeated attempts to contact him in her 5-page inquiry filed with the court. She stated that Adams introduced himself to her via inmate messaging on February 27, 2025, but she had not failed. Whew. Okay. Bullock complained about Adams' lack of response to her repeated attempts to contact him in her 5-page inquiry filed with the court. She stated that Adams introduced himself via inmate messaging on February 27, 2025, but had since failed to respond to phone calls, handwritten letters, and emails from third-party representatives. Boone, as we all know, is no stranger to changing attorneys. In the years and months preceding her trial, she was represented by 8 attorneys before Judge Michael Cranick ruled she forfeited her right to counsel and would have to represent herself. James Owens stepped in at the last minute and volunteered to act as an attorney during the trial. Boone now has until September 1st to file the appeal. Now, knowing this, there are some rhetorical questions that only Sarah Boone and possibly the next attorney can answer. 1. Will there be another attorney to step up to be Sarah Boone's appellate attorney? And 2, will she file this appeal on time? If I were a betting man, and I always like to say this, I'm a businessman, not a gambling man. But if I were a gambling man, I would be pushing all my chips all in to say, no, she's not going to make it. I've watched so many different Karen videos, it's not funny anymore. This is a real life convicted criminal Karen. She wants this done her way all day, every day, until she can get this appeal in. Newsflash, Sarah Boone, or should I say, criminal Karen. This is not Burger King. You can't have it your way. So we're gonna go with this editorial right now. Monday didn't ease us in. It throws us into the fire. A baby survives a massacre, teacher becomes a killer, cop brutalizes a man already in cuffs. This is just we got so much going on, but Monday reminds us that justice doesn't always arrive first. Sometimes it's the last one to show up, and when it does, it's already too late. Now, we move on to all. And we start with a brand new trial. The return mail murder trial. State of Montana versus defendant Jordan Palmer. A Montana man is standing trial on charges he killed his neighbor in a shooting that began with a misunderstanding. Right. It's always a misunderstanding. Jordan Palmer pleaded not guilty to a single charge of deliberate homicide, according to court records. In charging documents reviewed by MTN News, Palmer told Belgrade police officers that he shot and killed his neighbor after Stephen Campbell attacked him on April 19, 2024. When police arrived, they found Palmer standing over Campbell's body with a gun in his hand. Palmer allegedly told officers, "This guy attacked me. I expletive shot him." Investigators say Palmer found a piece of mail on the road and was going to the associated address to place it in the correct mailbox when Campbell confronted him and accused him of breaking into vehicles. That's according to a report from KULR. Palmer denied the accusation and told detectives he opened fire when Campbell threatened him and started trying to hit him. All of a sudden, as I'm looking over case highlights from the last few days, and I just skimmed over it briefly, I'm thinking, how in the world Are you going to you shooting under a man who's just making bold claims that you're breaking into a car? Really? This is gonna be one of those crazy cases. We're gonna see what happens in that. So stay tuned. Next up, a veteran who disarmed a Michigan Walmart stabbing suspect speaks out. Yeah, yeah, there was a stabbing that happened at a Michigan Walmart. Who would have thunk that? Matthew Kolakowski was shopping for fishing gear and snacks with his daughter at a Michigan Walmart over the weekend when he heard an employee yelling, "He's got a knife," followed by sounds of screaming. Then he saw a man rushing toward the checkout counter. All of a sudden, I see him pop up, and I swear we locked eyes for a minute. And I yelled at my daughter, "Stay here." So I just took off running, Kolakowski said, recalling the moment he decided to confront the man accused of stabbing 11 people at the Traverse City store on last Saturday. Bradford Gill was charged with terrorism and 11 counts of attempted murder. Police said they had no apparent motive for the violent attack carried out with a 3.5-inch knife. The actions of Kolakowski and some other men drew effusive praise from Grand Traverse County Sheriff Michael Shea. Overnight, the strangers became online celebrities for their heroics as a video showing the confrontation spread swiftly on social media. Kolakowski said that as he followed the man out of the store, he saw him plunge his blade into an older woman outside. Having no weapon himself, Kolakowski grabbed a shopping cart, hoping to not Walmart, all straight. Having no weapon himself, Kolakowski grabbed a shopping cart, hoping to knock the man down as he gave chase. He just ran right behind her and buried his knife into her back, right in front of me, Kolakowski said. He pulled the knife out and then went to take off, then stopped and hesitated and turned around like he was going after her again. That's when he noticed me with the grocery cart. I just went as hard as I could, and just got him on his ankles with the grocery cart from behind. Kolakowski, a 39-year-old disabled veteran, was quickly joined by another man with a shopping cart, stopping the man, later identified by authorities as Gill. A third man pointed a gun toward the man, repeatedly demanding he drop the knife. He eventually put the knife down and Kolakowski jumped on the man, restraining him until police quickly arrived. "Honestly, I didn't hesitate at all," said Kolakowski, speaking from his home in nearby Kent City. Though he was wary of being stabbed himself, he said, "I just kept going." He eventually put the knife down, jumped on the man, restraining him until police quickly arrived. "Honestly, I didn't hesitate at all," said Kolakowski, speaking from his home in nearby Kansas City. Though he was wary of being stabbed himself, he said, "I just kept going." Shea said the 11 victims were men and women ranging in age from 29 to 84, including one Walmart employee. All were expected to survive, officials said. Authorities said 42-year-old Gill has a history of mental health problems and has been arrested or ticketed numerous times in the Petoskey, Michigan area since 2001. He has also received In 2017, he was found not guilty by reason of insanity after being charged with damaging a burial vault and tipping over grave markers at a Petoskey cemetery. And police in Petoskey reported speaking twice with Gill in recent days about loitering. In a statement Monday, the Petoskey Department of Public Safety said you are the agency and sought and received a court order Friday to replace Gill in protective custody, deeming him a risk to himself and others. But they could not find him until the Traverse City stabbings occurred. Gill's mother told Petoskey News Review in 2007 that her son had been in a long-term cycle of mental illness. Beverly Gill, at that time, praised police and judges, whom she said were trying to help him. He's fine when he's on his medication, she told the newspaper. The problem is his illness tells him he isn't. He is fine. He needs any action. At his arraignment, Gill appeared agitated and seemed to suggest he was homeless. A not guilty plea was entered for him, and bond was set at $100,000. All right. Kolakowski's brother-in-law, Chris O'Brien, who recorded the video, said the crazy scene unfolded incredibly fast and that Kolakowski's actions surely prevented several more stabbings. It's his courage that is the crazy part. It was something to witness, he said. A guy was stabbing people. We were just next on his list if we didn't do something, right? O'Brien said. Matt was determined to make sure it was stopping then and there, as sure and he sure as hell did that. And I give a lot of respect to Kolakowski. I mean, that is a very risky move, but it was also a brave and bold move as well. Take down this person any way you have to keep any more preventing more stabbings that was yet to come. So props to Matthew Kolakowski. In fact, let's give that man a round of applause. Now, the next story on our docket coming up is the manhunt that's on the way right now for the person who killed the couple at Devil's Den State Park. And we got a lot covered on that too. Arkansas police say the killer of a married couple who had been hiking the remote Devil's Den State Park with their young daughters was likely injured during the weekend attack and released a sketch drawing of a man wanted for questioning. The composite sketch, which was released Monday night and depicts a man wearing a baseball hat, was the first image Arkansas State Police was given to the public as the search for the killer entered a fourth day. The man in the drawing was described by police as a person of interest, who was seen in the park Saturday. Authorities have not provided a possible motive or elaborated on how the couple was killed. Oh, and when I say Saturday, I mean last Saturday, not this past Saturday. 43-year-old Clinton David Brink and 41-year-old Kristen Amanda Brink were found dead on a walking trail. Their daughters, who are 7 and 9, were not hurt and are being cared for by family members, authorities have said. Along with the drawing, state police released a statement saying the suspect likely sustained an injury while attacking the couple. It did not go into further detail. Authorities have asked the public for days to report tips and urge trailgoers. Along with the drawing, state police released a statement saying the suspect likely sustained an injury while attacking a couple. Didn't go into further detail. Authorities have asked the public for days to report tips and urged trailgoers who are at Devil's Den to look through their photos and videos for possible images of the suspect. State police said they have received numerous calls, but have released few details about the investigation. The suspect may have fled the rugged 2,500-acre park, which has weak cell phone service, in a car with a license plate partly covered by tape. Authorities have not provided a possible motive or elaborated how the couple were killed. The family had just moved from South Dakota to the small city of Prairie Grove in northwest Arkansas, and their water had been connected less than 2 weeks ago. That's according to Mayor David Falk. Clinton Brink had been scheduled to start a job as a milk delivery driver Monday morning in the nearby Fayetteville area, according to Hill and Dairy, his employer. Clinton and Kristen died heroes protecting their little girls, and they deserve justice. The Brink family said in a statement, "They will forever live in all of our hearts." Officials described the suspect as a white male wearing dark shorts, a dark ball cap, sunglasses, and fingerless gloves. He was seen driving toward the park exit in a black four-door sedan with the license plate number covered partly by tape. The car, possibly a Mazda, may have been traveling on State Highway 170 or State Highway 220. We're just really hoping that anybody who captured any video or pictures or anything suspicious, just let us know. State Police spokesperson Nick Genty said, "We're investigating any and all tips we get." The FBI says its Little Rock field office is assisting the state police in the investigation. Devil's Den is located near West Fork, about 140 miles northwest of Little Rock. Devil's Den located near West Fork, about 140 miles northwest of Little Rock, the state capital. The park is known for its hiking trails and rock formations, and is a short drive from the University of Arkansas in Fayetteville and Walmart's Bentonville headquarters. Few visitors were at the park, and the trails remained closed. Rangers had stepped up patrol at Devil's Den, and said Shane Lewis, the secretary of the Arkansas Department of Parks, Heritage, and Tourism. Arkansas Governor Sarah Huckabee Sanders called the deaths horrific and said law enforcement will not rest until the perpetrator is brought to justice. Danica Harrell, a nurse at a rehabilitation center in Montana, said the Brinks also lived in that state for several years, starting around 2018, and played on a recreational volleyball team. In the summer, the Brinks would set up a volleyball net at a local park and encourage people to play, she said. Harrell, I should say, said that when she struggled to find childcare, the Brinks allowed her daughter to stay with them without a thought, and that Kristen Brink would often bring a plate of food when she brought the girl back home. They were selfless and unconditional with their love and support for their friends. Investigators asked for potential witnesses to review their phones and videos from the park south of Fayetteville. The bodies of the couple were taken to a state crime lab where the manner and cause of death will be determined. And as we go on, there is an update. The assailant was identified. If I can find that article. There we go. This was, as we found out, was a teacher who admitted to this heinous crime. In fact, I'm going to take you to video from Court TV covering this development.
We did confirm this morning that our suspect's DNA has been a positive match to the DNA that we suspected to belong to our suspect at the scene. During an interview with investigators, the suspect indicated that he did commit these murders. We executed a search warrant at his residence. There were articles found there that are consistent with being involved in this particular crime, and I will let Major Rhodes speak more of that or more to those details. We do believe he acted alone. We have absolutely no reason to believe that there's anyone else involved, and we do not anticipate any future arrest or any other arrests beyond the suspect. I'm going to go ahead and pass off to Major Stacy Rhodes. She can walk through a little bit more of the information, and I'll return to the podium and we'll answer any questions we can.
Well, good afternoon. As he indicated, I'm Major Stacy Rhodes. I oversee the Criminal Investigation Division for the State Police. And I kind of want to walk you through how we initiated and progressed through our investigation. So, as you all know, we responded to a call for service at the state parks. Two young children were found and indicated that something had happened to their parents on the trail. That initial information that came from the kids gave us our first starting point, which was a description of a suspect. There was another witness at the park that we encountered that gave us additional information about the suspect and a particular vehicle that he was seen leaving the park. With that, we took the information, completed and let me kind of, we'll start there. So from there, we had a pretty good description of our suspect. We did our initial release. Other witnesses came forward that were on the trail during the time that the murders occurred that did not see the murders, but brought forth video footage, photographs that they had taken on their day trip to the park. From that, we obtained a photo. We interviewed witnesses and were able to compile a composite sketch of what we believed our suspect looked like. With that, we received dozens and dozens of tips. With the initial vehicle information that we received, it being a black sedan, one of the initial descriptions was that it was sporty. From that, we received well over 5 or 6, maybe close to 10 videos of this particular car from homes and businesses along the routes in and out of the park. So we were able to ascertain a pretty good description of this vehicle. So with that vehicle information, that became critical in identifying our suspect. So with the photos or the tips that came in with the composite and the photo, as the Colonel said, we received over 500 tips. And initially we were using the names and information to come out to compare with, did they have black vehicles? Did they meet a certain criteria of vehicles? But as we began to hone in on the vehicle, it became clear that it was a Kia Stinger. And we used that information to vet various owners. And our suspect was identified. And with that, we sought him out and we located him at a local barber shop there in Springdale. We took him into custody. And with that, we spoke to him, and he made statements indicating that he had committed these heinous acts. And our job didn't stop there. We executed a search warrant on his house and also on the vehicle. We are still waiting a lot of testing at the crime lab. But as the Colonel said, DNA that was recovered at the initial crime scene matched his DNA that we pulled last night.
Good afternoon. My name is Brandon Carter. I'm the prosecuting attorney for Washington County, Arkansas. The first thing I want to say.
All right, we are going to take a break here. Of course, we're going to stop it so we can bring you back. We can hear everything from the prosecuting attorney, but she just detailed really what sounds like an outstanding investigation to catch the alleged killer very quickly, saying he admitted he did it, that he committed these heinous acts. Stay tuned. We'll be right back.
Own children.
That legendary trials.
It's a busy day here at Court TV, but we don't want you to miss this. We're going to go back to Arkansas. We are listening to a presser on the man who has now been charged with murdering 2 people while hiking with their kids at Devil's Den State Park. The 2 children, 7 and 9, the daughters were fine there with family. We want to go back in for more. We just heard the details of the investigation leading to the arrest. Now we're hearing from the prosecuting attorney.
Good afternoon. My name is Brandon Carter. I'm the prosecuting attorney for Washington County, Arkansas. The first thing I want to say here today is that my thoughts are with the Brinks family. There are 3 girls who tragically lost their parents in this case. And although today is a good day for law enforcement, there's a shadow over it because of the tragedy that occurred on Saturday. I want to commend the state police for the work they did in this case. I couldn't be more proud to be in Arkansas today. I couldn't be more proud to be a resident of Northwest Arkansas right now, and I'm confident and satisfied with the work that law enforcement did in this case. Especially, I want to know the cooperation I saw between local agencies in this case. I could name them all off, but I have a list here of 7 to 9 agencies that worked hand in hand to quickly solve this crime. And I commend every law enforcement officer that worked on this case. I also commend any member of the public that provided us information that led to the solving of this crime. I want the public to know that they're safe. The defendant in this case is innocent until he's proven guilty. But I'm confident that we have the right defendant in this case, and that the public need not worry going forward. Someday they're going to open Devil's Den State Park, and I'll be on the trail myself when that happens. The defendant will be spending time in Washington County Circuit Court over the course of the coming days. It is my intention to use the full weight of my office to bring this defendant to justice for the Brinks family.
Before we open for questions, just want to touch real briefly on something that gets lost in this sometimes, and that's the family story. we've spoken to the family quite a few times over the last several days, and what we heard consistently is what a loving mother and father they were, loving husband and wife that they were towards each other. And they absolutely protected those girls to their fullest extent, to the point that it cost them their lives. We're in awe of this mom and dad. We're also in awe of these girls. The information that they were able to provide to start us down this path, to be able to make this arrest, it all started with those two little girls. It's incredible. We also don't want to forget that there was a third sister. Thankfully, she was not with the family on the trail that day, but she suffered just as tragic of a loss, and we need to keep that in mind. Because of that, I would plead with you and the public to please be sensitive to the fact that there's a family that's grieving. It's hard to express because I can't understand it, what they're going through. Misinformation hurts. Speculation hurts. When they read things, when we talked to them earlier today, they expressed that to us, that they're reading things in social media, they're reading things that are just simply not true. And people are speculating, they're talking about things that are not factual, and it hurts. There's no place for that. Along those lines, we have to be very careful in an investigation to be calculated in the amount of information that we put out and when we put that out. I can tell you that this investigative team had one mission and one mission only, and that was to put hands on the suspect and to get him off the streets. And on a daily basis, we got together and we talked about what we felt like that we could put out to the public and what was going to be advantageous for us in the investigation and what could potentially be detrimental. One thing that we did not want to do is put information out that was going to take attention away from someone that we needed to look at. You have to remember all the information that we're working off of started with two little girls that witnessed the most horrific thing that you could ever imagine. That was the base of everything that we had. So we had to be careful about relying solely on that information. We had to collaborate that. We're also working in an environment that is half a mile into the woods. So by the time that we get the information from these little girls, and then we collaborate that with members from the public, they can talk or they can, give us further information based on the suspect description and things like that. And then that leads us to a vehicle, and then that leads us somewhere else. This is not an episode of CSI. It's not going to be wrapped up in a 1-hour episode. It takes hours and hours to develop that information, cooperate that information, and know that it's good information, and know that it's something that we can put out. The last thing that we want to be responsible for is putting information out that's going to hinder the investigation or hinder someone's their likelihood of calling us and putting us onto a suspect that we need to be looking at, because it didn't meet all the markers that we thought it should meet. So I hope you can be understanding of that, and I hope as we move forward from here that the speculation and a lot of the talk and a lot of the chatter, especially on social media, that people will be very sensitive to that. This family's been through enough, and they don't deserve to be victimized any further than they already are. And with that, I'll open it up to questions.
Colonel, can you elaborate more on what was the reason behind this? What was the motive for this? Was this random, or what happened there? And what was the cause of death? How were they killed?
As far as the motive is concerned, it's part of the investigation. It's two parts. The first part of the investigation is always going to be to identify and apprehend the suspect. The second part of the investigation is a lot of the whys and a lot of the details. That's still a part of the investigation. I can tell you that we have no reason to believe that there was any known association between our suspects and our victims. There's nothing to indicate that at all. It appears to be a completely random event. As far as the weapon that was used, it was a knife. Our victims died by stab wounds. Yes, ma'am.
Thanks, Colonel. We've spoken to a few parents from students who he was their teacher in different states, and they all kind of gave this synopsis of perhaps he was a predator. Their children felt like he preyed on younger aged girls during his time teaching in those states. We were wondering, have you been exploring any connections to the crimes that McGann may be connected with, and any indication his first time committing this? Was he after those girls? Were those his target?
From what we have no indication to suggest that the girls were his target.
Do you believe this was his first time that he just went to that park that one time that day? I heard potentially somebody suspicious could have been there the weekend before. Was he just that first time at the park, or do you think he was laying out and calculating?
Honestly, that would be pure speculation on my part. Now that we have our suspect in custody, there's going to be a part of the investigation that's going to go back, and they're going to look at timelines, and they're going to look at kind of his movements leading up to that. And hopefully that will give us all a better picture of why he did this, how long he had planned this, things like that. But right now, that's all part of the investigation. It would simply be speculation on our part.
I guess so that'll come from a later date. Alright. Next up, the New York City gunman who killed four was targeting the NFL offices. What was on this person's mind? Four people were killed and another was wounded in a shooting at a Manhattan office building. Among the dead is New York City police officer Diderol Islam. The suspect, identified as Shane Tamura of Las Vegas, Nevada, also died shooting himself in the chest on the 33rd floor of the building at 345 Park Avenue, according to authorities. New York City Mayor Eric Adams said that the gunman was attempting to target offices for the National Football League but entered the wrong elevator. According to the Associated Press, a note was reportedly found on Tamura's body claiming that he suffered from CTE, a degenerative brain disease that has commonly been linked to contact sports like football. We are deeply saddened by the tragic accident that occurred in New York City, the NFLPA said in a statement obtained by Scripps News. 345 Park Avenue is a part of our football family, and we at the NFLPA extend our sincere condolences and support to the people who work in this building and to the families of those who lost their lives. We also want to express our deep gratitude to law enforcement and emergency personnel who responded to those impacted. NFL Commissioner Roger Goodell acknowledged the attack as an unspeakable act of violence, saying one NFL employee was seriously injured in the attack but is hospitalized and in stable condition. We believe that all of our employees are otherwise safe and accounted for, and the building has nearly been cleared, Goodell said in a statement. We are deeply grateful to the law enforcement officers who responded to this threat quickly and decisively, and to Officer Islam, who gave his life to protect others. Detail how the incident unfolded. New York City Police Commissioner Jessica Tisch said surveillance footage showed Tamura exiting a black BMW on Park Avenue between 51st and 52nd Streets while carrying an M4 rifle. He entered the building's lobby and immediately opened fire, first shooting the officer, then a woman who had taken cover behind a pillar. He continued firing as he moved through the lobby, shooting a security guard near the elevator bank. A fourth person was shot but survived. Tisch said tomorrow then allowed a woman to exit an elevator unharmed before riding it up to the 33rd floor. There he fired additional rounds as he walked through the offices of Rudin Management. One person on that floor was killed before Tamura fatally shot himself. Law enforcement officials in Las Vegas said Tamura had a documented history of mental illness. Tisch said Tamura's vehicle had traveled across the country before arriving in New York City. It was tracked through Colorado on July 26th, then Nebraska on July 27th, and most recently Jersey before entering the city. New York City Mayor Eric Adams paid tribute to Officer Islam, saying he died a hero. He embodies what the city is all about. He is a true blue New Yorker, not only in the uniform he wore, but in his spirit and his energy of loving the city. Adams said Islam was an immigrant from Bangladesh who had served on the force for more than 3 years and was assigned to the 47th Precinct. He was married with 2 young sons. Tisch said his wife is pregnant with their 3rd child. President Donald Trump is set to return from an overseas trip to Europe, also said he has been briefed on the incident and offered condolences. I trust our law enforcement agencies to get to the bottom of why this crazed lunatic committed such a senseless act of violence, he said on his Truth Social platform. My heart is with the families of the 4 people who were killed. including the NYPD officer who made the ultimate sacrifice. God bless the New York Police Department, and God bless New York. And still I ask the question, what was on the mind of Shane Tamura? What was he going to do to anybody working in the NFL's offices? Whew. Next up, a woman tells the victim after a daycare shooting, "You gotta die." Now that's bone chilling in and of itself. Telling someone you gotta die. A Florida woman is facing murder charges after allegedly shooting the father of her children outside the daycare. Mindy Osteen is charged with first-degree murder, aggravated child abuse, and weapons offenses after the deadly shooting outside Auntie Lily's daycare on July 25th that killed Christopher Jones. In an arrest report reviewed by Court TV, detectives with the Bradford County Sheriff's Department said surveillance showed Osteen arrive at the daycare just 3 minutes after Jones arrived to pick up their 2 children. The children can be seen exiting the building first, then hugging Osteen before Jones exits and straps both children into the backseat of his car. Jones walks around the vehicle and sits in the driver's seat, where Osteen then meets him and opens fire, police said. Osteen is accused of firing 5 shots before Jones got out of the car and ran toward the daycare. As he was running, police said Osteen continued to fire and chase him. Jones found himself trapped between 2 doors when he tried to get back inside the daycare. Police said Osteen appeared to clear a malfunction on a weapon before approaching Jones and firing 3 more shots. Officers who reviewed the video said Jones could be heard moaning and children's screams were audible from Jones's vehicle. After the shooting, Osteen allegedly put the gun in Jones's vehicle and repeated, "Please let the monster die." She then returned to Jones and said, "You gotta die, Chris. You can't kill." Name redacted. Police said Jones responded, "Help me." To which Osteen said, "Chris, you can't kill." That name redacted again. Jones said, "I'm not killing nobody." When police arrived, Osteen was still on the scene when she was going through the contents of Jones's vehicle. When she saw deputies approach, Osteen put her hands in the air and said, "I'm right here, y'all. I've done it in self-defense." There were 6 children and 2 employees inside the daycare at the time of the shooting, and Osteen remains behind bars without bond. Wow. I'm still trying to wrap my head around what was she thinking. Ay, 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 ay. The only reason why I'm unable to come up with a good comment for this is because I'm still trying to wrap my head around it. Alright, let's see. Next up. Lots of coverage on Ghislaine Maxwell. First, she said she was willing to speak with Congress with immunity. Yeah, but that's when we find out that the Epstein and Maxwell grand juries only heard from two witnesses. We're gonna go to Court TV with coverage from this, headed up by the host of opening statements, Julie Grant.
Welcome back. In our spotlight this morning, now that Ghislaine Maxwell, the ex-girlfriend and madam of Jeffrey Epstein, has spoken to the federal government, we're wondering what she told them. So Maxwell recently met with a top Justice Department official, and according to her attorney, was asked about 100 different people, and she answered every question. In 2022, Maxwell was sentenced to spend 20 years in prison for helping Epstein sexually abuse underage girls. In a jailhouse interview with Talk TV, Maxwell wasn't exactly empathetic toward the victims when Epstein died behind bars without answering for his crimes.
Epstein died, and they should take the disappointment and upset out on the authorities that allowed that to happen.
Maxwell is also asking our U.S. Supreme Court to overturn her conviction. So, is there a deal to be made here? A release from prison, perhaps, based on the information she shared? Let's bring in our guest to talk about this. Still with me, former United States attorney. He's a practicing criminal defense attorney in the private sector now, William Ehlenfeld, and the director of the National Center for Victims of Crime. She's also an attorney. Renee Williams is here, too. Great to have you both on this. William, let me start with you here, please. The possible things that could come out of this meeting. I think everybody's wondering, so what happens? Is it a release? Are more people going to be prosecuted? Tell us what we should be thinking about, please.
So first off, it's highly unusual for the Deputy Attorney General of the United States to go and conduct a witness briefing to debrief someone who's either a witness or a defendant or a convicted criminal. And so this almost never happens. When I was U.S. Attorney, I didn't jump into those kinds of meetings unless it was a case I was personally handling. Otherwise, I let my staff do that kind of work. And there's reasons for that. You know, when you're at a high level in office or at the Department of Justice, you don't want to make yourself a witness. You don't want to get down into the weeds and do the work of the people that are really on the front lines. You're an administrator as the Deputy Attorney General, not actually a prosecutor. So highly unusual that he did that. But you know what's going to result from this? It's a little bit unclear at this point in time. What we do know is that she was given a Queen for a Day letter. That's basically immunity to talk to the government. And so she talked about things that perhaps she did wrong, but was able to provide information about others. There's the potential that other people that perhaps committed crimes could ultimately be prosecuted, and she could be a witness. Now, you typically don't sit down for such an interview unless you're going to get something in return. The media reports indicate that she has been off nothing. There are no promises made in exchange for her information. You know, I don't know if that's the case or not. But typically when you have somebody sit down and you offer them immunity for the day and they talk about other people, they expect to get something in return. So it remains to be seen. And just in the normal world of the DOJ, and I'm not sure that this is normal what's happening here, but in the normal world of the DOJ, if somebody offers information that allows you to prosecute someone who's done harm to others, whether it's through drug trafficking or violent crime or something else, you're typically going to receive some sort of benefit, some sort of reduction in your sentence. So I'm sure that's what she and her attorney are hoping for. Of course, they're taking that other angle going up to the U.S. Supreme Court, or at least they hope to get into the U.S. Supreme Court to try to attack her conviction that way.
A really, really helpful context and insight you're sharing with us, William. Thank you for that. Renee, of course, I want to turn to you and talk about the victims and the sentiment that's out there publicly with so many of these people who just feel so frustrated by what they perceive as a real lack of justice being served in this case. Would you share your thoughts on this, please?
Sure. Well, I think there are many, many victims that we probably don't know about, and that is because what happens in trafficking is that traffickers groom their victims. And so there are a lot of women who are probably still very afraid to come forward because there's some very powerful men out there. We don't even know the scope or the breadth of what the files say. And so I think we can't even say in cases like this because this case is like something we've never seen. And so we are just going to kind of keep waiting for justice for some of these victims because it will take a long time before they're ready to come forward, if they're ever ready to come forward.
That's such an excellent point, Renee. I want to show a clip now. This is Ghislaine Maxwell talking to Talk TV, and she's saying that she believes that Jeffrey Epstein was murdered in the jail, that he didn't die by suicide.
I believe that he was murdered. Well, I was shocked. And I wondered how it had happened. Because as far as I was concerned, he was going to... I was sure he was going to appeal. I obviously wish I'd never met him. You know, looking back now, I probably wish I had stayed in England.
Oh, I'm sure she does. Renee, this topic of the victims, that his death was such a blow, I think, to so many people who were interested in seeing him prosecuted and essentially, publicly destroyed for the crimes that we know that he committed based on the evidence and things that were done in the past. If he got a sweetheart deal on, we won't even go there. Tell me, do you think that we're ever going to see this death case reopened with him? Do you think there's ever going to be any more of a spotlight put on how he died in the jail?
No, and in some ways I hate to say this, but I don't know how much it matters for the victims on how he died. I think what we are seeing with some of these victims is the same thing that we see with many victims in the justice system, is that there is no justice, no formal mechanism of justice. And so that's why we see so many individuals reach out to the civil justice system and use the civil justice system. And it's something that we tell folks at the National Center quite often is sometimes you have to find peace without justice because our justice system sometimes just fails. But as far as Epstein's death, I don't think we'll ever know what happened. I'm not sure that it's worth it to reopen that case. Personally. I think that might be a controversial statement, but I just don't see the value.
Yeah, no, I really wanted your opinion on this. Asking other show guests, we've talked about this with others, and it's as you both know, this is a really a heated battle going on. There's many facets of this. We stay away from politics, as you both know, on Court TV, but yeah, fair questions whether we'll ever see anything open there and whether these victims will get justice, or as you said so beautifully, Renee, sometimes it's just about finding the peace. We'll leave it there for now, but again, Renee is the Executive Director of the National Center for Victims of Crime, and we'd love to have you back again very soon. Renee, thank you so much.
so many different dips, loops. It's basically a roller coaster ride. And until there's anything concrete, we're gonna keep an eye. We're gonna keep an eye on this particular case. Next up, a Karen Reed update. She files a formal request asking for her Lexus and her phone back. Karen Reed, acquitted on the murder of a police officer boyfriend. Now she wants her car and her phone back. One month after she was acquitted of murdering her boyfriend, Karen Reed is asking prosecutors to return the alleged weapon in her case. A jury found Reed not guilty of hitting her boyfriend, Boston police officer John O'Keefe, with her Lexus SUV and leaving him to die in the snow. She was convicted of drinking and driving and sentenced to probation. Now, through her attorney Stephen Buzang, Reed has filed a formal request with Norfolk Superior Court asking for the return of her 2021 Lexus LX 570 and her personal cell phone. The Lexus, which was taken into police custody in the hours after O'Keefe was found dead on the lawn of a friend's home, was key evidence in her murder trial, while prosecutors pointed to the vehicle's broken taillight as evidence of Reed's guilt. Her defense attorney suggested that investigators had planted pieces of the taillight in an attempt to frame their client. The filing says Reed's team has attempted to negotiate the return of the property with prosecutor Adam Lally, but has not heard back. Honestly, I say give it back to her. They have no further use for it. Why keep it? Same with her phone. Next up, a Diddy update. He's asking for release on a $50 million bond ahead of his sentencing in October. As you may recall, Sean Diddy Combs was acquitted of the most serious racketeering and trafficking charges, but he was found guilty of prostitution charges under the Federal Mann Act. In fact, instead of me talking about it, I'm going to let Court TV tell you about it.
Welcome back. We're shining our spotlight this morning on the case against Sean Diddy Combs and his latest push to get out of jail. He's awaiting sentencing on prostitution-related convictions. His lawyers just filed a brand new motion for bond. So what's it mean? I sat down with his lead attorney, Mark Agnifilo, to find out. With me now, Sean Combs' attorney, Mark Agnifilo. Mark, great to be with you. Thank you for being on the program today. And might I just say, I got to see you deliver the closing arguments in the case, and you were an outstanding advocate for Mr. Combs.
Oh, thank you very much, and thanks so much for having me.
You're very welcome. So let's get into this bail package that you have proposed. I read your motion, and you talk about the exceptional facts of this case and how the way the Mann Act is being applied is kind of like one of a kind. Would you walk us through what you mean by that, please?
Sure. So the Mann Act was passed in 1910, and it's changed a few times through the years, but really what it's geared at, what it's focused on, is prosecuting people who make money from the business of prostitution. And that's not the allegation against Mr. Combs. The allegation of Mr. Combs, what the jury found, essentially was that he was a user of services provided by sex workers, essentially a John, for lack of a better word. And the Mann Act just historically hasn't been applied to Johns. It's a financial statute. It's really been applied at people who look to make money from prostitution. And so since that's not how it's being applied here, we made the argument that we have to, under the case law and the statutes in this area, that this is an exceptional reason, and that Mr. Combs should be considered for release on bail because of it.
Mark, I read in your motion you say that Mr. Combs may very well be the only John sitting in a jail right now for his crimes. What makes you say that?
So we've done a nationwide survey of Mann Act cases, and we're not all the way finished, but we've looked at probably close to 100 cases. And we don't see any other case where a John, the user of prostitution services, is being prosecuted under the Mann Act. There are instances where the user of prostitution services has some kind of connection with the arranger, the organizer, the people who make the money from the prostitution services. But in terms of just being a straight user of services provided by a sex worker, we think he might be the only person in the country.
I certainly see what you're saying and can appreciate the legal argument you put forth in your motion for bail for Mr. Combs, Mark. And even if the judge agrees, let's say the judge agrees that this is an exceptional application of the Mann Act, and your client may be the only one who's jailed right now. You've cited every other case you can find. It's an ROR type bond situation. What about the other component that we know the judge is very concerned about, and that is your client's
So I think what was happening around the time of the incident that was testified to at the trial is that Jane was in fact helping him write a letter to get into one of these programs. And at the end of the day, he didn't get into the program that I think the letter was directed to, but we got him to another program, and he did start, therapy and counseling in that program, and did that for several weeks before he was arrested. So that's what your question is. The answer is yes, that is true.
And thank you for that, Mark. Is he availing himself of any programs now in the jail?
So the MDC doesn't have the programming that some other jails do, because it's not a final holding facility. It's really for people who are in a pretrial posture. So it's by its nature somewhat transient. So other prisons where people go to serve their sentences have much better programming, and so the programming at the MDC is not really that well established. That being said, we've cobbled together therapists and people who go in and speak with Mr. Combs, and he is availing himself of that.
When we come back after this break, we're going to turn our attention to sentencing. Currently, the date is set for October 3rd. Remember, Diddy was acquitted of the crime of racketeering conspiracy, acquitted of the sex trafficking offenses, convicted of transportation to commit prostitution. That carries a maximum allowable penalty of up to 10 years in prison. When we come back, I ask his attorney what he's hoping for in terms of a sentence, and Diddy's plans after it's all said and done. We'll be right back.
I'm Bethea'S Byte, and welcome to Closing Arguments.
What's happening when the time comes for him? Should John Combs be sentenced to? And what are his plans when the time comes for him to be released eventually? My conversation with his lead defense attorney, Mark Agnifilo, continues. Mark, I want to talk about sentencing, please. Have your expectations with the federal government changed at all with Maureen Comey being let go from her position?
No, I thought Maureen Comey was an outstanding lawyer, and is an outstanding lawyer, and I think will go on to have a terrific career, regardless of where she is. I think it's a loss to the U.S. Attorney's Office, and it's unfortunate, in my view, what happened to her personally. I got to know her and all the members of the government trial team pretty well during the trial, and I have a great deal of respect for all of them, including Ms. Comey. But no, that's an outstanding office. The Southern District of New York has a deep bench, as they say. They're very good lawyers in the office and on this trial team. So I don't think the presentation of evidence or arguments will suffer, even though Maureen left.
Mark, it seems like your team and the government are just miles apart on what kind of a sentence would be appropriate for Mr. Combs. What is your greatest hope, your most ideal hope for sentence for him?
So my hope, obviously, is that he gets out as soon as possible. We filed an application this morning, and hope, obviously, is that the judge sees the wisdom and agrees with us. The government will oppose it. And the government will oppose it for reasons that they believe are sound. Now, in terms of sentencing, we believe that, a sentence along the lines of time served is more than sufficient. If you look at what Johns are sentenced to, even if they're prosecuted in the first case in this country, no one's doing close to the time that Mr. Combs has done in jail. So I think we have to treat like cases alike, and I think he should be released in short order.
Mark, what are his hopes for his life? Because at some point this will all be said and done. We don't know what exactly the sentence will be that the court imposes, but after that, does he hope to return to music?
That the phrase he uses with me, and I can share it, he said that I could, is he says he feels he has more to give. And I think that's the focus. I think that he has spent a lot of time reflecting. He's a religious man. He's a man who has 7 children. The long-term relationships with whom he had 4 kids, has passed away, but the rest he takes good care of the women he's in a relationship with. He's really a very caring, dedicated person, and so I think he wants to emphasize that part of his life. Come out of jail, spend some great time with his children, who he misses very much. They get to see their dad, and I think he's going to be happy in the short term, having the simpler pleasures in life, but I expect he's a genius in my view, and he has unparalleled talent and ambition and vision. And I would say vision is probably the most pronounced of all those things. And I expect big things out of him. But I think we need to let him have a little transition, have some downtime. I just spoke to him an hour ago. I said, I'm not going to rest until you feel the hot August sun on your neck, and have the simple things in life, and you can take it from there. And I think he sees the wisdom in that.
Mark, he really couldn't have a better advocate. I mean that sincerely, advocate to advocate. I was incredibly impressed with you and what I got to see and how passionately you've worked for him and his defense. One last question before I know we have to let you go. As you know, no cameras are allowed in federal court, and that's something I hope that changes one day. Tell me, if the public were able to have watched, do you think it would have perhaps changed any public opinions? In other words, is there anything you think the public would have missed in not being able to actually see the trial?
That's a great question, and it's such an interesting issue. I mean, there's something about federal court that's wonderfully traditional. They didn't have cameras in 1789 when the Southern District was created, and it hasn't changed. And there's so much about trying cases in federal court where things haven't changed, and there's so much about that that's wonderful. That all being said, I do think the public would have come to view Mr. Combs very differently than the way he was depicted in the tabloids and in these lawsuits, which lack merit. And I wish that they could have seen the evidence firsthand, the way the jury did. And one thing I want to throw out, I mean, not too much, but there's been a little second guessing I've seen of the jury verdict by some people in some publications. And this was an immensely dedicated jury. They were on time every day. They paid close attention. They all took notes. You can tell when a jury is really functioning at 100%, and this jury was. And I wish that everyone could have seen what the jury saw. I think that would have been very good for Mr. Combs and very appropriate for the world to have seen it with their own eyes.
Most definitely. And the respect you showed us in this interview, you're exuding for the other side. Everyone's just doing their job. The government did what they felt was best under the circumstances, following the law as they saw, and you all did your job advocating for your client. Mark Agnifilo, thank you so much for the conversation. I hope we can talk again sometime.
Thank you. I hope so too.
All right, so now let's take a look at the defense's bond proposal package. So Diddy's legal team is proposing that their client be released on a $50 million bond and that he be allowed to live in his home in Miami. I should say it's a mansion, it's really a mansion, as he awaits his sentencing in October. Now the bond would be co-signed by 3 financially responsible people. His travel would be limited. It'd be limited to Florida and to New York, and his passport would be surrendered. His lawyers say if necessary, they would even add in home detention, so electronic monitoring, private security, mental health treatments, also substance abuse treatment, and electronic surveillance to make sure that he stays where he's supposed to stay.
All right, guys, you heard about the bond package. I'm trying to pull up a comment that one of you guys left for me in the post section, and I want to elaborate further on my response that I put on this. Let's see, is this it? Yeah. But before I get to that, there is one other update I have on this, and that came a little bit later, and that came over the weekend. Prosecutors seeking substantial prison term for Sean Diddy Combs. Alright. Prosecutors say they are now expect music mogul Sean Diddy Combs could face a prison sentence substantially higher than the 4 to 5 years they once thought he was likely to face after his conviction on 2 prostitution-related charges. They made the observation late Thursday in a Manhattan federal court written submission in which they opposed Combs' request to be released on a $50 million bail while he awaits his October 3rd sentencing. In early July, 55-year-old Combs was acquitted of racketeering, conspiracy, and sex trafficking charges carrying potential life terms, but was convicted of 2 counts of transportation to engage in prostitution for arranging for girlfriends and male sex workers to travel to engage in sexual encounters that he filmed. Each prostitution-related charge carries a potential maximum of 10 years in prison. Prosecutors said after the verdict they thought that federal sentencing guidelines meant to prevent wide disparities in sentencing for the same crimes would likely call for a prison term of 4 to 5 years. But they said Thursday they believe the guidelines range will be substantially higher, raising the risk Combs will flee. Judge Aaron Subramanian will have wide latitude in determining a sentence and can choose to ignore the guidelines, which are not mandatory. Combs' lawyers said they believe the guidelines, if properly calculated, will call for 21 to 27 months in prison. On the day of the verdict, prosecutors won a bail fight after defense lawyer Mark Agnifilo argued Combs should be freed immediately on bail. Subramanian denied the defense request, saying Combs had not met the burden of showing by clear and convincing evidence a lack of danger to any person or the community. But he said Agnifilo could renew the request. In doing so, Agnifilo cited other cases that were comparable to Combs' conviction in which defendants were granted bail, and he cited severe conditions at the Metropolitan Detention Center in Brooklyn where Combs has been held since his September arrest at a New York hotel. He also said Combs was treated unfairly for engaging in a swingers lifestyle in which he and his girlfriend sometime invited male sex workers to join them in multi-day marathon sex performances. Prosecutors said in their filing that Combs' conviction on the prostitution-related counts carried a minimum requirement that he remain in jail prior to sentencing, unless he could prove exceptional circumstances, which they said he cannot. They said he should remain in prison as a danger to the community, a claim that Agnifilo disputed in his papers. Sean Combs will not be violent to anyone, as we said in court. This jury gave him his life back, and he will not squander his second chance at life, nor would he do anything to further jeopardize his 7 children not having a father, and 4 of his children not having a parent at all, Agnifilo wrote earlier. Prosecutors also said conditions at the federal lockup had improved considerably before Combs was arrested. A federal judge in 2024 had blasted conditions at the jail, including extensive lockdowns and inadequate medical care. Prosecutors said cases cited by Agnifilo in which other defendants received bail were not comparable to the crimes Combs was convicted of carrying out, particularly because of his propensity for violence. The defendant's extensive history of violence and his continued attempt to minimize his recent violent conduct demonstrates his dangerousness, that he was not amenable to supervision, they wrote. The defendant utterly fails to establish by clear and convincing evidence as required that he does not pose a danger to the community. Now, I mentioned that I had received a comment regarding that particular article, and the comment went as follows. I thought he was out. Oh, this is courtesy of one of my fellow YouTubers, his Sally My Jack. He said, I thought he was out. Either way, this was BS. The jury got it wrong. His privilege and power and money got him a sweetheart deal. He is absolutely a dangerous sexual deviant who I have no doubt would permanently silence those who spoke out. What he did was horrific, and what pisses me off even more is that no child sex crimes were brought against him, and the victims that did speak got a slap in the face and a reality check that they don't matter. He didn't only sexually abuse and rape adults, kids too. They deserve justice. All the victims do. And this is where we separate the court of public opinion from the court of law. They have the jury has already looked at the evidence, which we didn't get to see. They looked at the evidence. They got to hear all the testimony presented, and again, as I stated in my reply to his Sally My Jack, what sweetheart deal? Diddy went to trial. He was found not guilty on racketeering and trafficking charges, which were the most serious, and was found guilty of the prostitution charges under the Federal Mann Act. I even had to do the digging on what the Mann Act was to find out exactly what Diddy was found guilty of, and because maybe I'll give him this much credit. Maybe because of his celebrity status and all, he may spend 21 to 27 months behind bars for the for on the federal charges. But that's it. That is all. If it goes further, you may spend up to 10 years. That depends on what the judge decides. Okay, now that we got through that, and I got an editorial on Wednesday, on the Tuesday. Tuesday is supposed to be the day the system wakes up, but it's waking up to bodies, not warnings. Suspect in Tennessee, out of prison less than a year. Teacher in Arkansas, hired weeks before the murders. Officer in Florida, which one we'll get to, only now facing consequences that happened years ago. We don't need justice to be reactive. We need justice to be preventative. We don't need the courts to clean up the mess. We need systems in place that will stop the blood before it spills. The Tuesday docket leaves us with the following questions. Why was Austin Robert Drummond freed when he was convicted? Why was Andrew McGann hired? And why did it take so long to hold a cop accountable? I'm going to get to that story in a little bit. The answers are not just legal, they're moral. If we don't ask these questions and others like them now, we'll be back here with the same editorials next week. The only difference is being new names, new victims, and the same silence. Now we get ready to move into Wednesday, which is the middle of a tumultuous week. And Wednesday is the day we pretend the system works. Let's see what we have for Wednesday. 4 adults arrested for allegedly caging and abusing adopted children. 4 adults. One of the stories I take absolutely personally because I'm an adopted child. I know what abuse. I've seen and I've felt abuse, and if I could, if only I could, I'll give you a small portion, and I'm gonna let Court TV take over. We're in Columbia County, Florida. 4 family members. Note that 4 family members in Florida are facing aggravated child abuse charges after investigators allege they abused adopted children in their care. Brian and Jill Griffith. That's the first 2 on the left-hand side of this photo. Brian and Jill Griffith, their husband and wife, mother and father, and along with their adult children, Dallin Griffith and Liberty Griffith. All arrested July 22nd and each being held on $500,000 bond at the Columbia County Detention Facility. The investigation began when a mandatory reporter at the family's church, the Church of Jesus Christ of Latter-day Saints in Branford, Florida, raised concerns after one of the Griffith children was found with a functioning electronic stun gun at church camp, according to the Columbia County Sheriff's Office. The Florida Department of Children and Families investigators initially visited the Griffith residence in Fort White to interview family members. During this visit, investigators observed the adopted children performing chores while the biological children were playing or watching TV. The children, ranging in age from 7 to 16, include 5 biological and 4 adopted children. Let's go to Court TV for more coverage.
Welcome back. This next story, it's a tough one. it's a tough one, but it's an important one. I'm talking about foster children, adoptive children living inside of a home. I want to show you 4 mugshots, and I'll explain who they are. Take a look. This is a mother, a father, and their 2 adult children. But all 4 are under arrest for what happened to 9 other children living in the mobile home that they were all residing in Florida. We believe that 4 of the children were foster adopted children. Horrific details in this one. So we're going to bring in Court TV field reporter Cody Thomas here in studio to walk us through these allegations. The first time I heard about this story, I was like, whoa, 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 what's going on
There's
here?
a lot going on here, Vinny. Very devastating, very sad, very tragic. This is all taking place in Fort White, Florida. It's a couple miles outside of Gainesville, Florida, to give you context of where we are. 9 underage children in this house, ranging from ages 7 to 16. We have, like you said, 5 biological kids between the mother and father, 4 fostered or adopted. Now, again, we don't know foster or adopted because both of those terms are used in the press release and the police report, so just to clear the air on that. But 4 non-biological kids, primarily African American. Now, the Florida Department of Children and Families got involved in this because one of those non-biological kids brought a fully functioning taser to church camp earlier this month. So, of course, that rose some concern among people who saw that, and they tried to lie and say it was a toy. Police figured out it was a real taser. So that's how they got involved. So, again, 9 parents or 9 kids plus the parents plus 3 adult children. Now, 2 got arrested. There was another adult child in the house. That's 14 people. Inside of a mobile home, Vinny. And so police say when they first arrived after the whole taser incident, doing their investigation, they noticed that these non-biological foster or adopted children were working, doing chores while the other biological kids just played, were living like children. But Vinny, it gets even worse. Take a listen to some more of these allegations. This is from a press release released by the Columbia County Sheriff. Take a listen to this. During the interview of the children by DCF, various forms of child abuse were discovered. Accusations of the adopted children being beaten with a cane by Brian and also locked in their bedrooms by Brian and the other adults. As a result of the allegations of physical abuse, DCF investigators obtained a court order to remove all of the children from the home. Over the next few days, Child Protection Team investigators conducted interviews with all 9 of the children. During these interviews, allegations by the children included being caged under the bunk bed by screwing in plywood to prevent his escape, being forced to lie on the floor by the mother Jill, and having her place a sheet of plywood on top of the child's body and press down on them, resulting in splinters and pain, being sprayed in the face with vinegar as a form of punishment, being given non-prescribed medication, being instructed to lie about what happens at home, and not being taken to or provided with adequate schooling to read or write. So, Vinny, you heard it there, just absolutely atrocious. And it goes on to say that these kids, they don't even know their full names or their birthdays. One of the teenage girls just admitted that she can't read. She's illiterate. And, mentioned not going to school, not getting an adequate education. They also talked about not being fed equal capacity or at all compared to the biological kids. But Vinny, there's a 10th child, a teenage girl. Now, they moved from Arizona. All this adoption happened in Arizona, then they moved to Florida in 2024. A 10th child was there, one of the adopted or foster children. She said it was so bad, according to the police report, that she somehow got in contact with her biological mother and begged her biological mother to take her back to Arizona, which
she got out.
She got out. And so police, of course, reached out to her. She's currently residing back in Arizona with her biological mother. Now, in the redacted police report, she talks about sexual assault allegations against the adult son that was arrested. Now, this kid is Dallin Griffith, one of the mugshots we just looked at. He's 21 years old. Now, according to that redacted police report, she says, quote, redacted, assuming that's her, stated that in April 2024, redacted disclosed to her that she had been sexually assaulted by Dallin Griffith, Jill and Brian's adult son. Redacted reported that the sexual abuse last took place in April 2024 prior to her departure. Redacted also disclosed that Dallin has taken redacted, and redacted, so assuming that's more of those children, in the bathroom, and she heard funny noises coming out of the bathroom. And Vinny, this redacted police report goes on to get more into detail, but I figured I'd spare some of those really graphic details there because they do get a little bit atrocious. But there's also some allegations against the father, Brian, that he molested some of the children. But again, Vinny, Brian, Jill, Dallin, Liberty, all arrested, all being held in $500,000 bond each.
All right, so sexual abuse, physical abuse, mental abuse, no education, locked into in their beds at night, some sleeping on the floor, punished with vinegar. All right, so how are they able to foster or adopt these children? That's right. That's the first question. Like, first of all, you've got 7 children of your own, so like it seems like 7 is enough, but apparently they get 4 to do some of the chores around the house.
Yeah, I mean, and that's the golden question, right? And it still kind of remains unclear because you have to jump through a lot of hoops to adopt and foster children. They make it, you know, somewhat difficult to weed out hopefully people like this.
Exactly.
So what I did, Vinny, to give viewers context about some of those hoops you have to go through, I checked the Arizona Department of Child Safety's website for the qualifications that you need to even start the process. And to my surprise, there's an 84-page go-to guide. This isn't even the full scape, but it's 84 pages of just like frequently asked questions and things you have to do, and it just outlines everything. And so right there on page 14, Vinny, it outlines what is expected out of the first placement once you foster a child. And it says, in part, the foster caregiver is to participate in planning to maintain the child in the school of origin, the school the child was enrolled in at the time they entered the foster home, unless it is determined that it is in the child's best interest to be enrolled into a new school. If enrolling in a new school, enroll the child as soon as possible or within 5 days, which is interesting, Vinny, because
it didn't happen,
right? And so then it goes on page 47. It talks about foster parent licensing. This is all in Arizona, by the way. It says in part, ARS 8509A states that foster home licenses are valid for 2 years. An annual life safety walkthrough by your licensing agency will also be done. You are licensed by the state of Arizona. You have a foster parent agreement with DCS and usually an agreement with your licensing agency. Should you choose to transfer to another agency, all of the records are property of the state of Arizona and should be given to the new agency at no cost to you. So what I took away from that portion, Vinny, is that that's one annual walkthrough out of an entire year. So if you clean up the house and the guy's coming to walk through and you tell the kids to lie about whatever's going on, lie that you're in school, lie that you're being fed, lie that
and that's part of the allegation, right? They told the kids to lie.
Right. So if you do that, you might be able to get by and circumvent the system there. Now, because they moved from Arizona to Florida, I did a similar thing. I went to the Florida Department of Children and Families to see what it takes if you're moving across state lines to Florida. And on their website, they have this whole outline of the screening process that comes with. And in part, it says, quote, in regulation, if the applicant or any other adult household member has resided in any other state over the past 5 years, requests for abuse and neglect histories must be made of those states. The supervising agency completing home study shall, at a minimum, conduct 2 visits to the applicant's home, inspect the entire indoor and outdoor premises, document the conditions, and conduct face-to-face interviews with all household members. Now, Vinny, again, that's 2 days out of 365. So that's an obvious, of course we know it's an obvious failure by the parents of these children, putting them through all this abuse that they're going through. Is it a failure by the system? That's left up in the air.
Yeah, because we don't even know the nature of the adoptions, like how it went down allegedly out in Arizona. Because if one was able to be returned, how did that happen without a state agency jumping in there? So something else is going on here for sure. All right, Cody Thomas, thank you so much. Let's bring back in our think tank, Rick Grundy, Josh Colesrud, and Ellis Polividis. Let me ask you, Josh, I'm looking at this now. Wait a minute. They're taking these kids from Arizona. They're bringing them to Florida. There's allegations of sexual abuse. There's allegations of physical abuse, putting the kids to work. This sounds like trafficking. Let's bring the feds in on this.
That's a great point. And, Arizona, my home state, I dealt with these issues both as a prosecutor and as a defense attorney. So in this case, specifically, this was a private adoption. So you don't have the overview that you would if it was through the government, for instance. And, when you're adopting kids and sending them from one state to another, the states don't necessarily share the information that they should. And so in this case, really all the adoptive parents, the ones in Florida, had to do was, basically had a clean record, that, and they're not supposed to adopt too many children. So the fact that they have adopted 4 should have raised red flags, and it didn't. But I think that the feds definitely should look at this for trafficking. It's multi-jurisdictional, and it seems like a coercive nature, which is going to be the key point. Were the biological parents coerced in any way, shape, or form to give their children up, for an illegal purpose, because that would be trafficking.
Yeah, Ellis, I think we're just at the tip of of uncovering what really happened here. Something stinks to high heaven. First of all, moving all these kids from Arizona to the middle of nowhere, Florida, where you could sort of, if you look where this house is, I mean, there's not a lot around there, so you can kind of fly under the radar until your son brings a taser to church camp. What are your thoughts about how much more prosecutors can do here?
Prosecutors are going to do a lot. The fact that already on your show we were able to find a 2024 sexual assault allegation, because if you look at the statement that we've seen so far, there wasn't a reference to sexual assault at this point. So the fact that that already exists and wasn't examined is going to be huge. Each of those kids had a history. Each of those kids should have a paper trail. All of those paper trails are going to be examined, and all of it is going to be looked into. And I assure you that if there is a failure on the part of any state agency for failing to oversee, there'll also be a civil component to this eventually. But right now, the priority is holding the individuals who are accused of this to justice, because this is malevolence, and they're going to really root this out, I assure you.
Rick, the other extremely troubling part of this, like everything's troubling, but so there's 9 young kids. It seems that the 4 foster/adopted children are doing chores, and they're getting the grunt of all of this. There's also a possibility, we haven't confirmed this, that they may all be African American, or a majority of them may be African American. Like, they're basically taking these kids and enslaving them, for goodness sake.
Yeah, I mean, it's obviously a very horrible situation. It was mentioned in some of the reporting on this that they are of a particular religious sect, which is oftentimes associated with large families and not necessarily involved that much or willing to be involved that much with the government. So if those adoptions, as Josh was saying, went through a church organization, you're not going to have that any kind of, you get some oversight, but you're not going to have the oversight you're thinking about when there's 51As already in place. Parents are supposedly working for unification when the adoption happens, or any of that. And picking these people up and getting them to Florida was probably no more difficult than putting gas in the car and loading everybody in there. So the second tenet to that is, I can tell you that with respect to my other 2 colleagues here today, I'm guessing that Massachusetts has that much more laws and regulations when it comes to child protection. The problem is, if you don't have the infrastructure to put those regulations in place and have the laws abided by, you have horror stories like Court TV covered just 6 months ago.
Absolutely.
With children.
Right at time for this segment, Rick.
Stories like that makes me sick to my stomach. It makes me sick to my stomach, ladies and gentlemen. 9 children removed from the home because of 4 monsters. And I'll call them monsters because of what they're accused of: abusing and caging children. Now, I mentioned that they're all being held under $500,000 bond each at the Columbia County Detention Facility. Honestly, they deserve to be in a cage under no bond. That's what you do to animals. I said that in the earlier story, and I'm saying about this one too. Excuse me. Next up, body cam footage shows Brian Kohlberger's traffic stop 3 months before the murders. Newly released footage shows Brian Kohlberger being stopped for speeding 3 months before he killed 4 University of Idaho students. Latah County Sheriff's Office released footage of one of their deputies, Darren Duke, stopping Kohlberger in his white Hyundai Elantra for speeding on August 21st, 2022 at 11:38 p.m. According to the officer's report, he pulled over Kohlberger after witnessing him driving 42 miles an hour in a 35-mile-an-hour zone. Let's go back to Julie Grant, Court TV, opening statements for more on this story.
Right now, though, returning to our top story this morning, as we've got some newly released body camera video of killer Brian Kohlberger, just months before he murdered Madison Mogen, Kaylee Gonsalves, Zena Kernodle, and Ethan Chapin. His footage is from Moscow police from August of 2022. The killer got pulled over for going over the speed limit and was cited for not wearing his seatbelt. Now, prosecutors plan to use this video to link him to his white Hyundai Elantra, which was key evidence in the case. Take a look.
Hey there. I stopped you going a little fast. You didn't realize this is 35?
Oh, it's 35?
It is, yeah. So you're going
41?
Yeah, 43 is what the radar said.
Sure.
Oh, yeah. Do you have your license, the registration, insurance? Were you wearing your seatbelt when I stopped you? No. That's no good.
Just being honest with you.
Yeah, I appreciate that.
You guys are... There's absolutely no point. I'll be honest.
Yeah.
You have the radar.
Yeah. Yeah. Okay. Do you have a vehicle registration slip or something like that? Okay.
Or that give you my insurance.
Yeah, this is your insurance. That's good. Thing is, I'm on a overtime shift right now. One of the conditions is we have to enforce seatbelt laws, and so to write you a citation for that, it's $10 in Idaho. Not a huge deal, but yeah. Be right back. Can I get a phone number from you?
Yeah, why?
We need to put it on the citation as it goes to the court.
For future reference, I mean, I'm obviously an honest person, right? I told you I wasn't wearing my seatbelt. When people lie to you about that, say I'm lying to you about that, right? Just for my own knowledge. Honestly, go back and look at that.
With a seatbelt like this, I didn't check as I was coming up, so that's why I asked you.
Do you usually?
I should. I noticed you weren't wearing it, and I'm on this emphasis, and like I said, I'm getting paid by ICD, and they want us to enforce the seatbelt law, so I was being more aware of that. That's where I'm coming from.
Yeah.
Okay. All right. Have a good night.
So what do you think of this newly released video footage? Let's bring in our legal eagles. So happy to have on the show this morning attorneys Don Malarsic and Franz Borghardt. Good morning to you both. Franz, would you start us off, please? Your thoughts on Mr. Koberger, in this traffic stop?
Well, if you think about it, this is the most we've gotten from him. I mean, we've never really heard him speak in court before. We've never really seen much emotion. Even in the sentencing, he at most he smirked, Julie. So, that's number one. Number two is, isn't it interesting the questions he's asking about a seatbelt violation, about, his interaction? It's just kind of creepy. So, I think there'll be other information that comes out over the course of the next few weeks, months. This is probably just tip of the iceberg, but I mean, it just gives us a little snapshot into who he is. So,
Right. Yeah, you're right, Franzi. And we see he's like overly concerned when it comes to the traffic violations, but clearly has no regard for the homicide laws. Don Larson, let me go to you here. What did you think when you saw this creepy video? Franz is right. It is creepy. He does look like a creep sitting there. What did you think of him and his comments?
It's creepy. It's disturbing. And what's interesting to me is he doesn't really appear nervous. He doesn't appear like, he's worried about any consequences. And what's odd is he's really trying to kind of get in the head of the police officer. He's saying, hey, I'm honest. Doesn't that count for something? And he's trying to talk to him about job, how he does his job, why he does his job. And he's portraying himself really as kind of a victim. Hey, I didn't know, I was just driving. Aren't you going to give me a break? But what stands out to me clearly is this is a guy who is not nervous. He's calm, he's collected, he's in control, he's not emotional. He's asking really intelligent questions, trying to get out of clearly violating the law. And I think that's a little bit of insight into what unfortunately happens 2 months later after this traffic stop.
Mm-hmm. Yeah, great points, Don. I love what you said about how he may be trying to get in the head of the officer. Like at one point, he asked the officer, he said, say I lied to you about the seatbelt. And like, what does he get? What's the purpose of this? Franz, what do you think?
So I think the uncomfortable part about this is, on the one hand, it's a $10 seatbelt violation. On the other hand, he seems to almost enjoy what's happening a little bit too much. And, look, my thought from day one has always been, Julie, what happens if this guy gets away with it? Like, where does Koberger go in life if he gets away with the multiple homicides? Does he get a PhD and go and teach? Does he become a serial killer? What happens? But I think my takeaway from this is I would not be shocked, Julie, if there weren't other crimes that we don't know about yet.
That's a great point, Franz. I've seen some things swirling around on TikTok, on X. You don't know what to believe anymore. I mean, you don't know if you're looking at facts or propaganda anymore. You have to, confirm every single thing you see in cyberspace. But yeah, that's really interesting, and I'm sure we're going to hear about anything else, if he did anything else. Don, when I'm looking at him, we know he's a murderer. At this point in time, he hadn't murdered those Idaho students. It was just 3 months before August, and, we know the awful killings happened in November. Looking at him, I have this Ted Bundy, like he gives me Ted Bundy vibes every time I look at him, because just the way he speaks, he's so articulate, we know he's smart. Curious what you see when you look at him, having had so many, you've debated a lot of high-profile cases with some really bad people. Does he remind you of any other serial killers, Bundy, or anybody else you can think of?
Yeah, I think the Ted Bundy analogy is spot on. Ted Bundy was a guy, like Franz said, who seemed to be enjoying the limelight, enjoying the focus. And what strikes me is this guy is a complete psychopath. And what we see in psychopaths and homicidal psychopaths is they're not nervous, right? They're not agitated. They're not emotional. They're in complete control. Inside him, I'm sure it is a burning, crazy, insane, loud, nonsensical voice in his head, but what he shows is this really calm demeanor where he portrays himself as being in control. He's not afraid of authority. He's challenging authority. He's trying to figure out a way out of this mess. He's cold. He's calculating. And these are the guys that are terrifying, right? These are the guys that scare the heck out of me when I go to sit down and I talk to them at the jail, and they don't want to address the real issue. They want to talk about other things. They don't want to talk about themselves. They want to talk about you. They want to talk about the police. They do everything and anything to avoid any real accountability, and they deflect to everyone else and everything else. And there's no real emotion. You can see it in his eyes. He's focused, and that is really terrifying.
Yeah, I really appreciate what you said. They're done about the control. You're right. He likes being in control. It's very evident. He's emotionless. It's like, I think he's soulless too. When we think about whether we'll ever hear anything else from him, I've been getting this question a lot. Perhaps Franz and Don, perhaps you both have too, when people know what you do for a living and know you give legal analysis on cases like this one. Franz, do you think he will talk at some point to someone from prison?
I think he wants to talk. I think he wants to tell his story, whatever that is, but it will be very much a controlled burn, Julie, and by that I mean it's going to have to be on his terms. So I do think at some point there will be that very disturbing, creepy interview that we watch where he's being interviewed about the crimes. You know, I just can't help but feel that we're going to hear more from him.
Mm-hmm. Yeah, I think you're right. We shall see.
Indeed, we shall. In the meantime, Kohlberger is locked up for life for the murders of Madison Mogen, Kaylee Gonsalves, Xana Kernodle, and Ethan Chapin. Four life sentences to be served consecutively. But just when you think I'm done with... That's when you thought I was done with Kohlberger, I have yet another update on him. And this might be a good thing too. The update is now that Kohlberger has been moved to solitary confinement in an Idaho prison. Again, this might be a thing for Kohlberger. Brian Kohlberger is being held in solitary confinement at the Idaho Maximum Security Institution after receiving life sentences for murdering 4 University of Idaho students, an IDOC official confirmed. Kohlberger is being housed in long-term restrictive housing on J Block. A unit includes inmates in protective custody, long-term segregation, and death row. The unit can hold up to 128 individuals. Inmates in restrictive housing are confined to a single-person cell, moved only while restrained, and receive 1 hour of outdoor recreation daily. They may shower every other day, access religious services, place commissary orders, and communicate through JPay. Judge Stephen Hipper sentenced Kohlberger to 4 consecutive life sentences without parole just over a week ago for the November 2022 murders of Madison Mogen, Kaylee Gonsalves, Xana Kernodle, and Ethan Chapin. He also received an additional 10-year sentence for burglary and $270,000 in fines. Kohlberger pleaded guilty to all counts earlier this month, avoiding the death penalty. Survivors and relatives delivered emotional statements at his sentencing, with some confronting him directly in court, while others described lasting trauma and grief. Which will bring me to this update: Ethan Chapin's family speaking out after Kohlberger's sentencing. 1 week after Brian Kohlberger was sentenced for the brutal murders of those 4 University of Idaho students, the family of one of the victims is speaking out for the first time. Kohlberger sentenced to 4 consecutive life sentences 4 consecutive life terms plus 10 years in a plea agreement that spared him the death penalty after he pleaded guilty to murdering Madison Mogan, Kelly Gonzalez, Xander Kernodle, and Ethan Chapin at an off-campus home on November 13, 2022. While Mogan, Gonzalez, and Kernodle's families all delivered impact statements at Kohlberger's July 23rd sentencing, one family was noticeably absent. We've given a lot of thought to what we should say since July 23rd and have edited this a million times, Chapin's mother Stacy Chapin said in an Instagram post on July 31st. The entire situation has been a tough pill to swallow, but at the end of the day, we believe the outcome is the right one. Other victims' families have been less supportive about the case's outcome, with Gonzalez's father declaring he was furious after learning of the plea deal. Stacy's post offered gratitude to prosecutors, University of Idaho staff, and others before offering a final thanks to her son. You were only with us 20 years, but you touched the lives of so many people, from the time you were a baby to when we dropped you off at college. You were an absolute joy and the glue that held our family together. We remember your smile, your laugh, how you kept us in check, and the many ways you brought happiness and light to any situation. There will never be another you. There would never have been enough time with you. We love you, miss you, and promise to continue honoring your legacy. Ethan was a triplet, and Stacy's post references his siblings' recent graduation from the University of Idaho, and they continued attending after their brother's murder. And as you can see, this is the full Instagram post. As you can see, the triplets. And the article, it concludes by saying Stacey plans to continue talking about her son's murder and the DNA technology that led police to his killer. She is a confirmed speaker on a panel at CrimeCon in September 2025. And Court TV will be at CrimeCon and will bring you details from the panel. Well, let's just hope that, like I said, that'll be the last time I mention Brian Kohlberger by name. He did what he did. He pled guilty to it. I say, let his name never be spoken again. Let him rot behind bars. Let him rot behind bars. Next up, we have a sentencing in the shot 5 times assault trial. Texas versus Billy Delgado. A Texas man was shot as a strange wife while she was picking up their daughter. Daughter was facing charges, and we're gonna go to, I don't know whether it's conviction or sentence, but one thing's for sure, you're getting to hear from me first before we get to the video. He is sentenced to 50 years in prison. This sentence was passed just hours after his conviction.
I felt so much pain that I wanted to die at one point. I did ask to stop. I did not want to live anymore at one point.
State of Texas versus Billy Delgado. We, the jury, find the defendant, Billy Delgado, guilty of aggravated assault causing serious bodily injury with a deadly weapon to a family member. Felony of the first degree signed by the presiding juror. We assess his punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of 50 years.
Defendant Billy Delgado sentenced to 50 years in prison for the aggravated assault, the shooting of his now ex-wife, Erica Torres. As you can see in the video, Delgado shot at Erica 14 times. 5 shots hit her, but fortunately she managed to drive away, getting into a terrible accident down the road. She spent an entire year in the hospital, a whole year, recovering from her injuries. But she lived to tell her story, and she testified against Delgado earlier this week. This morning, I'm so pleased to welcome onto the program survivor Erica Torres and her mother, Edith Terrazas. Good morning to you both, and thank you for coming on today. First question to you, please. Erica, how are you doing this morning?
I'm doing okay. It's just trying to get back to what would be a normal day.
Do you feel that you've gotten justice?
I'm satisfied with the years. I'll be able to start over without having to look over my shoulder for a really long time, which is satisfying enough.
Mm-hmm. Yeah, you know, you said looking over your shoulder. I was wondering as I was watching the trial if it was a violent, abusive relationship, and abusive can mean anything, emotional, financial, physical, all those things. What was it like living with Billy Delgado? Was it an abusive relationship where you felt scared all the time and looking over your shoulder?
Living with Billy was always very, we always had to wonder how he was going to wake up, how he wanted to do things that day. It all depended how he would wake up. I can't say that every day was a bad day. I can't say that. Mm-hmm. But when it was bad, it was bad. And yes, it was toxic. It was very unhealthy.
Thank God you're out now, Erica. Edith, let me turn to you. How are you doing this morning?
Good morning.
Satisfied, like my daughter said. Our biggest concern was, them being able to move forward, her being able to start her life again, being able to make a new life for her and my granddaughters. It is very hard to explain. My oldest granddaughter, she's 11, and kids nowadays use social media, so she's very aware of what's going on, and she was very relieved to see the amount of time that he was going to be, behind bars, because she doesn't have to be scared that he's going to come and hurt her mom.
Edith, thank you for that. I wanted to ask how the kids are doing because they've been through a lot, as you both know. How would you say they're doing now with some finality here to this awful, awful time?
My girls have actually Yes, they have trauma. They've been doing therapy. But my girls showed a lot of resilience. They strived really well in school. Granted, with everything that was going on, they had a really good school year. They've been playing sports. They have their friends. They've been able to be around and not have so much change. They're doing good, but they do have in the back of their mind that I'm not coming home. They worry so much every time I leave the house without them that I'm coming home.
When you were in the hospital, how often did you think you wouldn't come home?
I don't think it was so much that I wasn't going to get to come home. It was more of what was my life going to be after I left the hospital. I'm a very active person. Prior to that, my worry was that I was going to be unable to do the stuff that I love to do. But at the moment, I'm not able to, but hopefully with time, I will be able to do the stuff that I love to be doing. But it was mainly just scary enough to know that I may have a hole and my intestine in a bag for the rest of my life. So that was pretty much the scary part.
What do you think's been tougher, Erica, getting through the physical pain and the physical difficulties and limitations and setbacks, or the mental anguish and grief of going through such a traumatic series of events?
I would have to say the hardest part has been the mental part. You don't have control over it. Prior to all of this, I never knew what anxiety and depression were at all. And PTSD and having trauma, didn't know what it was to be like. And now it's like I have no control over my own mind. It's frustrating. It's really sad that I have to deal with something that I didn't have to deal with before.
No, it is. You shouldn't have to deal with this, and we're so sorry that you are. You've been incredibly brave, incredibly courageous. Tell me, that day when your cousin testified about how she was on the phone with you and you didn't want to hang up with her, it seemed that you were scared. It's like you almost had a sense that something bad was going to happen. What was going through your mind then, Erica?
It was just unbelievable at the fact that somebody can unload a gun on somebody, especially not knowing what was going on with the whole situation at hand. It was uncalled for, and I was really beyond scared.
Oh, absolutely. I mean, it was despicable what he did. Absolutely despicable, horrible. Before he even raised the gun up, when you were just driving there, and I'm sorry if my question was confusing, when your cousin was on the phone with you, you were talking and said that you didn't want to hang up, you wanted her to stay on the phone with you. Was it like, did you think he was going to do something when you were going there that day to pick up your daughter?
No, I didn't think he was going to do anything to me. I thought that he was just going to start arguing and fighting with me, which was I was trying to avoid that. And usually I was able to avoid it if I had somebody with me in the vehicle or if I had somebody on the line. He would just,
He would see you were busy and leave you alone. No, that makes sense, Erica. Edith, I want to ask you, please, of course, mom knows best, right? And, I wondered as a parent, did you ever get feelings about him or have some kind of a sense, any red flags, or ever anything that happened prior to this incident where you maybe thought something's not right with Billy Delgado?
Yes, because of their disagreements, and they had already separated several times prior to all of this, I had expressed my feelings to my daughter and told her, that I really did not think that the relationship was healthy and that they needed to go their separate ways. But somehow, as much as she wanted to try to start things on her own, Mr. Delgado would always come and look for her and tell her that he was sorry and that he was going to get, counseling and he was going to get some help, and that he wanted to have his family together. And, Erica wasn't because she didn't want to be with him or she didn't love him. She also wanted to try to fix things, but unfortunately, the way she mentions, Billy has those two sides. He can be, a charming person, a nice person, someone, you can sit down with. But then he has his moments when he's a completely different person and, you just can't reason with him.
That seemed very evident from what we saw in the trial, and that's exactly what I want to talk with you both more about. Edith and Erica, stand by kindly, please. We'll hit a break. When we come back, we'll hear more about the story that the defendant told on the stand at trial, and also what it was like.
My body was in so much pain. I didn't even know where pain was radiating from. I kept passing out. I just did not want to die.
We'll hear about Erica Torres' perspective, plus a shocking story out of Tennessee, a manhunt underway for a suspect who killed 4 family members and left a baby abandoned on a front yard.
Realization that I got shot because I felt like I couldn't see him, and just hearing I remember on my window.
Court TV Legendary Trials.
Heard 3 bangs on my windshield as I was going, and the only thing I remember seeing is literally his hand as I turned to the side as I was passing him, and just hearing gunshot after gunshot after gunshot. I came to a realization that I got shot because I felt like I couldn't breathe. I kept trying to gasp for air, and as I was gasping for air, I felt like something was tying around my waist so tight. Like I looked down to see my abdomen, and I just see red on my dress.
That was shooting survivor Erica Torres testifying against her now ex-husband, Billy Delgado. Erica was shot 5 times in the abdomen. While driving away, she got into a terrible crash, but miraculously, she lived to tell her story. She spent a year recovering from her injuries in the hospital, and Delgado was convicted of aggravated assault and sentenced to spend the next 50 years of his life in prison. I'm so pleased to have on the show with me survivor Erica Torres and her mother, Edith Terrazas. Erica, when we look at that video and what happened to you, both videos, the shooting video, the crash video, all of it, and hear about how many times you were hit, how much time you spent in the hospital, it's incredible. It's incredible. Him at such close proximity to you, that you survived this. Do you often wonder how you survived it?
Yes, I do. I do sit a lot wondering how is it possible? Sitting in the hospital for a whole year with injuries that do not have a textbook. Like, oh, you have from this day to this day, month-wise. Everything was always so, we just have to see. There was never a clear answer. Even till this day right now, we still don't have a clear answer of how I'll be later on, which is scary. But I do have hope and I have faith that if I was able to survive that shooting, I was able to survive the surgeries and the pain that it was going through, I'm sure I'll be able to see the light at the end of the tunnel when it's time.
Yes, you will. You're so strong, so brave. You were incredible on the witness stand. How was that for you? How was that getting in front of all those people and recounting something so horrific?
It was really, really nerve-wracking. Really nerve-wracking. I have this thing where when I'm so nervous, I smile and laugh. So it was just really nervous. I was very nervous, and just the simple fact that I got to, face Billy face to face, actually look at him. I was nervous, but at the same time, I was satisfied. So he knows that, I survived, and I'm going to be able to continue life.
Yes, you will. Erica, what did it feel like when Billy Delgado's defense team kept trying to paint him as the domestic violence victim and paint you as the aggressor?
It was really hard to watch, especially the things that they were saying online, or like not online, but on the stand. It was really hard to watch because I know deep down inside, I'm not a bad mom. I do not abuse my kids. So it's really hard knowing that they were able to, say those kind of things about me online, knowing that I am Emmy's mom and I wasn't the one who shot somebody.
Right.
Go
ahead, please.
Would it be the other way if I would have shot him? Would they feel the way they feel right now up there on the stand? It felt like they were giving it as an excuse. It is okay to show you don't have a record, and you paint the other person as this horrible person who abuses you and your children, and it's not even true. I don't understand how somebody would want to be with somebody like that.
They were tough on you in the cross-examinations, especially there was one moment that stood out to us in the penalty phase when counsel was crossing you. Let's look back at that moment together now.
You have been in jail. Did you have a verdict experience while you were there?
No.
Back in 2012, you were booked into the Laredo Police Department for assaulting a family member. How many days in jail did you do for that?
I was not in jail. I was in there for 6 hours.
So how could you have picked up a cocaine charge if you're June 1st, 2024?
Again, I was not arrested by an officer. I am still pending those charges.
You have a brother named Louis?
Yes, I do.
Okay. And has he been to prison?
Yes.
For what?
I don't know.
Is your brother, you wouldn't know?
I don't.
Your Honor. Did you discuss his experiences in prison?
No, I don't.
It's irrelevant. Judge, it's relevant because they're trying to send my client to prison.
Eric, anything you would like to say or explain here and now about that and some of the accusations and things that were being brought up on that cross?
The proper investigations were done. And as well, the proper investigations were done and they were closed. And, my daughter, I've spoken to her, and she denies all allegations of any kind of sexual assault from my brother. She says that never happened. She's voiced to me that it was her dad who told her that. She says that never happened. So I'll take my daughter speaking to me, and she's very vocal. She's a very vocal little girl, and she will tell you how she feels. So I will believe her, and like I said as well, they did the investigation that they had to do, and it was closed. and allegations towards myself. I'm not a perfect person. Unfortunately, being with Billy brought out a really horrible person about me. I was married prior to Mr. Delgado, and there has never been any accusations at any point to the way they were with Mr. Delgado.
Erica and Edith, I'm curious, was the first time you heard the story about these allegations of abuse allegedly by your brother, allegedly with your daughter, was the first time you heard about it at this trial when he got on the stand, or had you heard it previously?
I'll go ahead and answer. Well, I'll answer first since I heard about them. The first time I heard about the allegations, Billy's mom actually had come to the hospital while Erica was in surgery. And she came and she was expressing, you know, how bad she felt about what had happened, and she couldn't believe it, and how she had been on the phone with Billy when all of this transpired, and how Billy had told her what my granddaughter had said about my son. And she's just the way she stated to the police, the way Erica's attorney said, she said, there's no way possible. And one of the things that I don't understand is she goes on the stand and says that she spent all of this time with my granddaughter and she saw all of these things. Why, if my daughter was such a bad daughter, why is it that they never called CPS before? Why did they never make an allegation before? Mm-hmm. How is it possible that my granddaughter went to daycare? She's gone to school. This past year, she went to pre-K. Not once has she ever showed any signs of abuse. She's a happy child. Regardless of everything that happened, she blossomed and excelled excellent this year in school. And she's been happy. A child that has been great. Abused and has gone through something like that would show some type of signs. What kind of mother does he have that saw these red flags and didn't do anything?
That's a fair
if
question.
If she alleges she spent all of this time with her.
Sure. Well, and it's kind of getting to what I was wondering about when the story came up. So it came up after he had shot your daughter, Edith. So essentially, you were saying the first time you heard it was when your daughter's hospitalized, and then his mother is relating it from him. Thank you for that.
Yeah, because he only disclosed it, apparently to his mom when he was on the phone with her, and then, that's how we were able to find out what he was saying in regards to his excuse for shooting my daughter, which still doesn't make any sense. If my son was the one who did, this, why go after her mother?
Yeah, it made no sense to me. I said it on my show the other day. I thought it was a garbage story. It was like he was looking for a free pass to commit an aggravated assault. Thank goodness you survived. Erica Torres, Edith Terrazas, thank you both for coming on, for answering all our questions this morning. Every good wish to you as you continue your healing journey with your family and with the children. Take good care.
Thank you.
Thank you.
And I echo those sentiments too. So as Julie Grant stated, we hope that nothing but the best for him. And as for Billy Delgado, he gets to spend the next 50 years of his life behind prison bars. To which I ask the same question with every defendant that gets sentenced like this: was it worth it? Was it worth it? We also now have a verdict watch. James Craig was on trial for murdering his wife using poisoned shakes. If we have the video, we'll go through that verdict. Yes, we do. This one will be short and sweet, but we're about to go to the verdict in this case.
At this time, then I'll ask Dr. Craig and his team to please stand for the reading of the verdict. As to verdict form, count 1, murder in the first degree. We, the jury, unanimously and beyond a reasonable doubt, find the defendant, James Craig, guilty of murder in the first degree. Verdict form, count 2, solicitation to commit tampering with physical evidence, Annabelle Craig. We, the jury, unanimously and beyond a reasonable doubt, find the defendant, James Craig, guilty of solicitation to commit tampering with physical evidence. Verdict form, count 3, solicitation to commit tampering with physical evidence, Casey Bohannon. We, the jury, unanimously and beyond a reasonable doubt, find the defendant, James Craig, guilty of solicitation to commit tampering with physical evidence. Verdict form, count 4, solicitation to commit perjury in the first degree. Jury, unanimously and beyond a reasonable doubt, find the defendant, James Craig, guilty of solicitation to commit perjury in the first degree. Verdict form, count 5, solicitation to commit murder in the first degree, Nathaniel Harris. We, the jury, unanimously and beyond a reasonable doubt, find the defendant, James Craig, guilty of solicitation to commit murder in the first degree. Verdict form, count 6, solicitation to commit perjury in the first degree as to Kassiani Constantinidis. We, the jury, unanimously and beyond a reasonable doubt, find the defendant, James Craig, guilty of solicitation to commit perjury in the first degree. As to verdict form, count 7, manslaughter, cause or aid suicide, we, the jury, find the defendant, James Craig, not guilty of manslaughter, cause or aid suicide. Let me then turn to the foreperson and ask, is this the verdict of the jury? Do all of you agree with this verdict?
Yes, we do.
At this point in time, you can be seated.
Jury convicted the Colorado dentist of first-degree murder in the poisoning death of his wife. Prosecutors at trial accused James Craig of repeatedly poisoning his wife Angela Craig by lacing her smoothies over 10 days in March of 2023. When those attempts failed, prosecutors said the dentist gave his wife a final dose of cyanide as she was hospitalized in a suburban Denver with symptoms that puzzled doctors. She was declared brain dead soon after. Craig stood with his attorney, as you just saw, while the verdicts on murder and lesser charges were read aloud in court. He then sat down and his attorneys rested their hands on his shoulder. Afterward, he huddled with his attorneys, quietly whispering as they waited for the judge to sentence him. The dentist didn't testify during the 2-week trial, and his attorneys didn't present other witnesses. The defense had suggested earlier at trial that Angela Craig may have taken her own life and faulted police for focusing solely on James Craig as the suspect. However, prosecutors said the dentist had offered other conflicting explanations for her death to other people. Toxicology tests determined Angela Craig died of poisoning from cyanide and tetrahydrolazine, an ingredient commonly found in over-the-counter eye drops, according to the coroner. Prosecutors argued Craig wanted to kill his wife to get out of a marriage he felt trapped in, adding he didn't want a divorce so he could protect his money and image. They also accuse him of trying to cover up the killing and asking others, including his daughter and fellow jail inmates, to fake evidence and testimony that would make it appear that his wife killed herself or wanted to frame him for her death. Prosecutors said photos from a hospital security camera shown in court depict Craig holding a syringe before he entered Angela Craig's room. After administering the fatal dose through her IV, Craig walked out and texted a fellow dentist with whom he was having an affair. Senior Chief Deputy Michael Morrow told jurors, including arguments. His wife's conditions quickly worsened. One of Craig's attorneys, Lisa Fine Moses, had told jurors this week that the image was blurry and syringes that investigators recovered did not contain any poison. She also said the couple wasn't in financial trouble and that Craig's cheating had been going on for years and had never been a motivation for murder. To which I say, if that was the case, then why didn't he just go ahead and deal with the divorce and get it over with? He wanted to save his money and his image. Well, that's the price you pay. If you felt trapped in a marriage, get out of it. Divorce. It's gonna cost you something, but hey, you want out, you got out. Alright, let's see. So that's Wednesday. Right, and here's what, and like I said, that was the middle of the week, and we pretend the system works on Wednesday. The courtroom becomes a theater, and the truth becomes a prop. Here's the examples. Nicholas Cassotis is using the devil made me do it defense. Only difference is it's not the devil, it's a man named Jim McIntyre. Andrew McGann will say nothing, but his silence screams guilt. And as for Austin Drummond, well, he won't even be in the courtroom. He's still on the run, still trying to avoid and or delay the inevitable. This is the day we watch lawyers spin, judge balance, and families break. Here's the truth. The courtroom isn't where justice begins. It's where it tries to catch up. And the gallery isn't where truth is found. It's where it's filtered for public consumption. Wednesday reminds us that justice isn't just about facts. It's about narrative control, emotional endurance, and who gets to speak. And too often, the ones who scream loudest are the ones who have already lost everything. We go to Thursday now, and the first thing we go to is the honor killing trial. Ihsan and Zara Ali facing attempted murder charges. They attempted to kill their daughter. And here is that
Please be seated. Juror number 11, are you the presiding juror?
Yes, Your Honor.
Could you please provide the materials that you have to the bailiff? I need to first verify that the verdict forms are in the proper format, so that's going to take a moment. The forms are the verdict forms are filled out correctly, and I will now publish them. We, the jury, find the defendant Ihsan Ali not guilty of the crime of attempted murder in the second degree as charged in count 1. We, the jury, having found the defendant not guilty of the crime of assault in the first degree as charged, or being unable to unanimously agree as to that charge, find the defendant Ihsan Ali guilty of the lesser crime of assault in the second degree. Special verdict form. We, the jury, answer the question submitted by the court as follows. Were Ihsan Ali and Fatima Ali members of the same family or household? Answer, yes. We, the jury, find the defendant Ihsan Ali guilty of the crime of unlawful imprisonment as charged in count 3. We, the jury, answer the question submitted by the court as follows. Were Ihsan Ali and Fatima Ali members of the same family or household? Answer, yes. We, the jury, find the defendant Ihsan Ali guilty of the crime of assault in the fourth degree as charged in count 4. We, the jury, find the defendant Zahra Ali not guilty of the crime of attempted murder in the second degree as charged in count 1. We, the jury, find the defendant Zahra Ali not guilty of the crime of assault in the second degree as charged in count 2. We, the jury, find the defendant Zahra Ali not guilty of the crime of unlawful imprisonment as charged in count 3. We, the jury, find the defendant Zahra Ali not guilty of the crime of burglary in the second degree as charged in count 4. We, the jury, find the defendant Zahra Ali guilty of the crime of violation of a court order as charged in count 5. I am now going to poll the jury, and what that means is that I'm going to ask each of you the same question. The first question I am going to ask is whether or not these are your verdicts, and then I'm going to ask whether or not these are the verdicts of the jury. Juror number 1, are these your verdicts? Are they the verdicts of the jury? Yes. Juror number 2, are these your verdicts?
Yes, Your Honor.
Are they the verdicts of the jury?
Yes, Your Honor.
Juror number 3, are these your verdicts?
Yes, Your Honor.
Are they the verdicts of the jury?
Yes, Your Honor.
Juror number 4, are these your verdicts?
Yes, Your Honor.
Are they the verdicts of the jury?
Yes, Your Honor.
Juror number 5, are these your verdicts?
Yes, Your Honor.
Are they the verdicts of the jury?
Yes, Your Honor.
Juror number 6, are these your verdicts?
Yes, Your Honor.
Are they the verdicts of the jury?
Yes, Your Honor.
Juror number 7, are these your verdicts?
Yes, Your Honor.
Are they the verdicts of the jury?
Yes, Your Honor.
Juror number 8, are these your verdicts?
Yes, Your Honor.
Are they the verdicts of the jury?
Yes, Your Honor.
Juror number 9, are these your verdicts?
Yes, Your Honor.
Are they the verdicts of the jury?
Yes, Your Honor.
Juror number 10, are these your verdicts?
Yes, Your Honor.
Are they the verdicts of the jury?
Yes, Your Honor.
Juror number 11, are these your verdicts?
Yes, Your Honor.
Are they the verdicts of the jury?
Yes, Your Honor.
Juror number 12, are these your verdicts?
Yes, Your Honor.
Are they the verdicts of the jury?
Yes, Your Honor.
Thank you. I am satisfied that these are the proper verdicts, that they are unanimous, and I accept them.
On October 18, 2024, Fatima Ali planned to run away from home to avoid going on a trip to Iraq. Her family searched for Fatima throughout the morning and located her with her boyfriend Isaiah on the campus of Timberline High School. The incident between Fatima and her father was captured on surveillance video from an inner-city transit bus approaching the school, as well as videos from several bystanders. Prosecutors said Ihsan Ali was angry with his daughter and placed her in a chokehold and squeezed her neck while students attempted to free Fatima from her father's grasp. The defense attorneys say they saw the incident differently and that the incident amounted to 53 seconds and that there was no clear evidence either parent tried to harm Fatima and she was going to take her home after she left home a second time in the same month. Zahra Ali, who was acquitted on the top counts but convicted of violating a no-contact order filed on behalf of Isaiah's father, has served more than the allotted time for the crime. She was released from Thurston County Detention Center following the verdict and must abide by any existing no-contact orders that remain in effect. Zahra has been in jail since October 2024. When asked what she would say to her daughter Fatima, Zahra said, "I want her to come home. I love her. I always love her." Ihsan Ali will stay behind bars until sentencing. He was acquitted on the top count of attempted second-degree murder, but was convicted of second-degree assault, unlawful imprisonment, and misdemeanor assault in the fourth degree. Ihsan faces a 12-month prison sentence, but has been in jail since his arrest last November. His scheduling is set for 2 weeks from today, Monday, August 18th. There you have that. Dad's found that both mom and dad found not guilty for the attempted murder of their daughter. Next up, a Virginia City Councilman is set on fire and the suspect is charged with attempted murder. Let's go to Virginia to find out what's going on there. A city councilman in Virginia was seriously injured when a man stormed into his office at a local magazine, doused him in gasoline, and set him on fire. An attack that authorities say was rooted in personal dispute, not politics. 38-year-old Lee Vogler, who has served on the Danville City Council for more than a decade, was taken by a medical helicopter to a burn unit in North Carolina after the attack. Police said the assailant, 29-year-old Shotzi Michael Buck Hayes, forced his way into Vogler's office at Showcase magazine, confronted him, then chased him outside and set him ablaze. Hayes was arrested at the scene on charges of attempted first-degree murder and aggravated malicious wounding. Investigators stressed that the motive appeared personal and unrelated to Vogler's work as a public official. Still, the assault added to growing unease over violence and harassment aimed at elected officials across the country, particularly as the boundaries blur between their public roles and private lives. There was no justification for lashing out, said Andrew Scott Brooks, publisher of the magazine. This type of acts of senseless violence needs to stop. 2 employees were in the building when the attack occurred, Brooks said. According to police and witnesses, Vogler ran through the office yelling for help after being doused in gasoline. A colleague called for help as Hayes chased Vogler outside and ignited the fire. "Our door is locked," Brooks said. They forced their way into the office and went to Lee. The next thing, Lee is running through the office covered in gasoline, yelling for our office mate to call 911. Hayes was being held without bond in Danville City Jail, police said. A message left with a phone number listed for the suspect wasn't immediately returned. A message was left with the Danville Public Defender's Office asking whether they will be representing the suspect. Showcase magazine is a monthly publication about Southwest Virginia and North Carolina. The magazine shares a small 2-story building with several other businesses in Danville. A woman who answered the door at the Vogler residence and identified herself as the sister of Vogler's wife declined to comment. A man at an address listed for Hayes also declined comment. Elected officials and politicians throughout Virginia quickly condemned the attack. Our prayers go out to Danville City Councilman Lee Vogler, who was violently attacked at his workplace earlier today, Republican Governor Glenn Youngkin said in a statement. We pray for a swift recovery for Lee and for peace to be on the entire Danville community. Brooks said he had no indication that Vogler felt unsafe at work or elsewhere. Vogler is a salesperson at the magazine, though at the small city media company, everyone does a bit of everything. He makes sales, but he also writes stories about our community, Brooks said. Brooks said that comes naturally to Vogler. His passion is being on the city council. He loves when people call them with a concern that he can help them with, and he has been an asset to the community for much of his adult life. He was young when he got on the city council, early 20s. He has made that his life. Brooks said outside of work, Vogler is a dedicated parent to his 2 kids. He's the one who coaches their sports teams, Brooks said. Danville is about 140 miles north of Charlotte, North Carolina. So what could have brought all that on? Who knows? But we know that that Mr. Hayes is going to be doing a good bit of time behind bars if convicted. Next up, we have the officer, as I mentioned in the editorials, is sentenced for slamming a handcuffed DUI suspect. I want you to remember that now. The suspect is handcuffed. Let's go to that sentencing right now.
Welcome to our first hour of Court TV Live. I'm Julie Grant. This hour, we are in the state of Florida. We're covering a case against a defendant, Jacob Cannon. Let's take a look at the background of how we got here at this point in the case.
I'm trying as hard as I can. Deal with it.
So this former police officer, Jacob Cannon, pleaded no contest for that moment we just saw there as he was arresting that woman in Florida. And today he's going to be sentenced for that crime. He's looking at potentially prison time. And let's take a listen to what his attorney and the prosecutor said as they were arguing about the potential sentence that he should receive.
Regarding any departure, I just want to make sure I got this right, that they are moving for a departure pursuant to an isolated, unsophisticated event for which he shows remorse, and that he's amenable to treatment. Specifically, I think the anger management, I'll let them put that on the record, that he's amenable to treatment. And for those 2 reasons, they are saying that they are able to, Your Honor would be able to depart if Your Honor put the victim injury points on there.
My understanding was, in addition to those 2, there was mention that I should consider the behavior of the victim, which could potentially go to a third grounds for downward departure.
So, and that's what I'd like for the defense to clarify, Judge. They made an argument about that. I don't know, and perhaps they can point out what evidence they have of that and what case law would support that. The state objects to that. I believe Your Honor can depart pursuant to isolated, unsophisticated, for which he shows remorse. Again, we object to a departure that you should not depart. I believe that you can depart pursuant to that he is amenable to treatment. However, I object to that. I don't think that you should depart for all of the reasons that I stated on Friday in my argument. Pursuant to that last litigator, if that's what they're arguing, I disagree. I do not think, number one, that there's competent substantial evidence of that. And number two, I do not think that there's case law that supports that. So I don't think that that's ground for departure.
Okay, thank you, ma'am.
And the last thing, Judge, they had kind of insinuated, there's no evidence of this, but insinuated an argument that Mr. Cannon was not receiving proper medical care in the jail. He had been there about 2-3 days on Friday when they addressed that. I'll let them address that and I can rebut that if needed. But again, I don't know if that's a movement for some sort of departure or what exactly the purpose of that argument is. But if it was something for departure, there would need to be actual evidence of that on the record that I would then rebut.
Okay. All right, Mr. Lambert.
Morning, Your Honor. Yes, it is that he is one of the reasons that he's amenable to treatment, and that they don't offer that specialized treatment in the prison. They only offer it outside. One of the downward departure reasons that treatment would be for mental health, not just anger management. Either explosive disorder or PTSD, depending on what they end up figuring out the mental health issue is. So yes, that is one of the reasons that she instigated. With regard to the slight evidence on that, that's all in the medical records that the court reviewed in the videos. It's just that attitude. It's not something that we're doubling down on, just pointing out. With regard to the case law and the points, Judge, the Lynn v. State case, Lynn had told the officer that he bit that he was HIV positive. That caused a huge issue with his mental health, with his family's health, with all of it. So it's kind of disingenuous to use that case as a comparator, but we do agree that it is within the court's discretion, but we do not believe it's moderate. But even so, the state does it sounds like the state agrees that there is a reason the court can downwardly depart if the court chooses to downwardly depart. So we would ask the court to downwardly depart and make it a treatment-based probation where he can get the help he needs. Thank you, Judge.
All right, so this was bad. This incident was bad, and let's talk about it, and let's take a look at it again. I'm going to bring in our guest. He is an attorney in private practice now. He used to head up the homicide unit in Norfolk County, Massachusetts. Rick Grundy is our legal analyst this morning. Rick, good morning. I want to play that clip again for you, and we'll get some analysis on the other side. So this is a DUI arrest. This officer was trying to have this suspect undergo a breathalyzer test, and things go really, really bad. Let's watch.
I'm going as hard as I can. Deal with it. Well, that's not my fault, you can't
Oh my. Rick Grundy, your thoughts on that, please.
Well, number one, if you're looking to go into a job where you're going to have pleasant interactions and develop relationships with the general public, don't go become a police officer. So that sheds the light on, and I don't know anything more about this officer, this department, training, whatever, but imagine this person put in a situation of true confrontation requiring de-escalation. This is a situation where you have a highly inebriated person in handcuffs, in custody, with another officer there. There is certainly no question that this officer is in any kind of fear or anything. And you have to look at this and think that with any form of proper training that includes extensive psychological testing, extensive training, an extensive probationary period with a seasoned officer where you're out on the street and have these situations and are confronting them with the proper guidance, that this would happen. You know, I think the statute of limitations have all gone. So I will tell you that as a prosecutor, the first time I tried my first case, I said to the police officer, "You're the first police officer I got to know that didn't have to chase me first." Police officers, I grew up in Newark, New Jersey. It was a tough town, and we respected police officers, but at that point in time, we also had a fear of police officers because we knew how things were handled there. We've come a long, long way from there. And what we've learned is that the respect that police officers are due and need to have in order to do their job is something that cannot be rooted in fear. In fact, it's not true respect if it's rooted in fear, and it doesn't work, whether it be a parent, a teacher, or a police officer. And this individual, I just think this is, I can't look at this and think this is the first sign of this. This is the first time these events, these type of signs have come out on this person. So quite frankly, if I were the judge, I would have said to counsel and the defendant, I don't accept your no contest. You'll stand before me. You'll admit that you're guilty of the charges, or you'll face a jury.
Excellent analysis, Rick. I really appreciate all the comments you made here. And yeah, as to your last comment, talk about that legally, if you would, please. The judge doesn't have to accept that no contest plea, right?
Correct. Now, that could be jurisdictional, state by state. I can tell you I've practiced in 6 states. I've had two trials, and all of them give the court the opportunity to reject a no contest plea. And I just think in a situation like this, I don't know what the PTSD claim is grounded in. If he's a combat veteran, I give all respect for that service. But again, this is not a confrontational situation. So in a situation like this, as a judge, I would not accept a plea from a person who is standing before me saying, look, you know, you could probably find me guilty, but I don't have the wherewithal, the appreciation for what I've done to stand before the court at this late date and say, I was wrong. I take full responsibility for my actions.
Mm-hmm. Right, Rick. Yeah, I mean, this is really bad for so many reasons. I mean, there wasn't prior aggression from her. You know, oftentimes we see officers get into altercations because a suspect takes a swing or there's something. Here, she's cuffed. So she's very drunk, as it appears from the video. And this was, you know, appeared to be unprovoked by anything other than maybe something verbal. I mean, just terrible. I wonder what happens to his career. And to full disclosure here, the sentencing happened on Tuesday, so we're going back a bit because we've had so much going on in terms of other trials. We haven't been able to show it. But Rick, do you think, is he done? I would think he's got to be done after this. What do you think?
I would certainly hope so, you know, and I know of situations where officers have gotten into these types of matters and they go on a job search and they'll go nationwide. And oftentimes they'll find a small department somewhere in the country that will take them on and give them another shot at it. You know, one of the things when you say the consequences of this that I noticed, and it's just a bugaboo of mine, is that he resigned from his position. Now, a lot of times, and when I was head of the criminal bureau at the Attorney General's office in Massachusetts, we handled a lot of police misconduct cases involving violence. They resign in order to protect their retirement as opposed to being fired. Right. So I question whether this department is allowing that. My opinion, the department in a situation like this, you can send in all your letters of resignation you care to, but I want it on your record, and I want it for the taxpayers of my jurisdiction to go down as you were fired. A lot of times, you know, unfortunately, with union issues in Massachusetts and other states, they'll accept the resignation because they don't want to have the 5 years of appeals.
Mm-hmm. Right, Rick. That's a really helpful point. This is a felony, too, as you know, Rick. For anybody wondering, he pleaded no contest to felony battery. So now he's got that. He's got a criminal record now. So really went on the other side of the law, as we say. Rick Grundy, I'm so glad you're here this morning. We'll hit a break. Stand by kindly, please. When we come back, we'll show you the key moments from the sentencing of this former officer in Florida. Major sentencing for former officer Jacob Cannon. So this case happened in Florida. He was an Ormond Beach police officer until an incident where he slammed a woman who was intoxicated and under arrest into a glass wall. It's all caught on video camera. He was doing it when he was trying to administer a breathalyzer test to that suspect. Her name is Shanna McCree. It happened last December. This guy pleaded no contest to felony battery. Take a look.
I'm as hard as I can. Deal with it.
Oh, my. So this guy pleaded on Friday, was sentenced on Tuesday. So we're going back and watching what happened at the sentencing hearing. Take a listen to the judge.
Mr. Cannon, would you please stand up with your attorneys? So I do agree with the defense that permanent disfigurement doesn't always necessarily mean moderate injury. I don't find the Lynn case or the citing of the Lynn case by the state to be disingenuous. I think it is helpful. And in that case, the court pointed out that scarring, along with the potential HIV issue in that case, was enough for moderate injury points. And I do think moderate injury points are appropriate in this case here. And I think that that's within my sound discretion to decide. And the reason for that, the reason I'm making that decision is Ms. McCree has a 1.5 to 2 inch scar right across the center of her forehead. She had 7 stitches for that. And then I think we're 7 months after the injury when she sat here next to me, just a few feet away from me. It's glaringly obvious, and that's something she's going to have to live with unless she gets plastic surgery to get rid of it. But it's red, it's raised a bit, and it's readily available to anybody who looks at it, readily visible. So I am scoring the moderate injury points. That unfortunately means that the defendant scores 19.1 months DOC unless I find grounds to downward depart. Obviously, this is a tough case, and let's talk about the grounds for downward departure. And I saw Mr. Lambert nodding his head when I was saying that I thought one of the grounds was that the victim, Ms. McCree, was somehow an initiator or provoker of the injuries that were caused to her by the defendant. And I've watched all of the videos. Ms. McCree was highly intoxicated. She was verbally abusive. But that's your job in law enforcement, to deal with all sorts of people, including people that are hostile, verbally abusive, and highly intoxicated. She was, in fact, screaming and combative at the hospital and had to be given medication and restrained, as your attorney argued. That was after the injury, though, after she had lost a significant amount of blood and had this huge gash across her forehead. I don't find that there's grounds to downward depart. I don't think that has been proven, and I don't think it would be appropriate even if it had been proven. Unlike the state, I don't think that this was committed in an unsophisticated manner. I do think it was an isolated incident, and the defendant showed remorse for it. But the reason I'm finding that it wasn't committed in an unsophisticated manner was because after the victim was injured, she was placed in a holding cell. I think ignored, as best I could tell. Nobody attempted to tend to her or give her any kind of aid. And then there were lies to the supervisor about how it occurred. So I don't find that was committed in an unsophisticated manner. I do agree with the state, though. The defense has proven that the defendant suffers from a mental illness that's unrelated to substance abuse or addiction, and the defendant is amenable to treatment. One of the mental health providers, I think, saw the defendant, it looked like only one time, and diagnosed it with PTSD based solely on his 7 years in law enforcement. I'm disregarding that opinion. I think that opinion it is not specific to the defendant. The other treatment was more and I find that is appropriate under the circumstances. I do find that you suffer from a mental illness that's unrelated to substance abuse, that you are amenable to treatment. I am going to consider, in addition, your lack of any criminal history whatsoever in the 7 years of public service that you've done through your job. And I want to be very clear, I am not downward departing because you were a police officer. I am downward departing because you have no criminal history, and I'm trying to treat you the same as I would anybody else under similar circumstances in a similar situation. So I am going to adjudicate you guilty. The reason for that is, as a convicted felon, you will not be able to own a gun, buy a gun, and possess a gun, and that's important to my sentence. I'm going to sentence you to 6 months county jail. Madam Clerk, how much credit does he have? He's got 11 days. Okay, you have 11 days of credit. That's to be followed by 2 years of probation, during which time you need to undergo a mental health evaluation and any recommended treatment. You will be required to surrender your law enforcement certification to the state of Florida, but I believe you've already done that, sir. And then I'm going to order restitution to the victim, Ms. McCree. I'm going to reserve for 60 days to determine that amount. And so if it wasn't already done, Madam Clerk, I'm going to revoke his bond today. And then the court costs are $770 plus 100 costs of prosecution, 100 costs of investigation, and that'll be a condition of your probation as well. Like I do with everybody else, I'm going to waive your cost of supervision for one of the 2 years of probation, and that's to encourage you to try to complete the terms of the probation and terminate early at that halfway point. Your attorney knows that you can file a notice of appeal within 30 days of me signing the judgment and sentence. And then the other thing I wanted to mention is that any of the items that were submitted and taken into evidence are public record currently, and defense may want to consider whether to seal the medical records. Okay. Anything else the court needs to address today? No. Okay. All right. Thank you, folks. Thank you.
6 months in county for that former police officer. Let's get some reaction from our legal analyst guest, attorney Rick Grundy. Rick, even though it's county, not state prison, not going to be a picnic for this guy, is it?
No, not at all. I mean, he's going in one of the worst categories that you want to go into due time, and that is as a former police officer. I think it's an appropriate sentence. You know, the thing is, you never know. I don't know with respect to Florida on a county sentence. If he was in Massachusetts, he would be eligible for parole after serving just 50% of that. So if he's looking at doing 90 days and getting out, I think that's kind of light. But, you know, I'm assuming that we're looking at a person with no prior record. You know, all roads to law school for pretty much everybody start with avoiding mathematics. But if that's a 2-inch gash, I really did poorly in math because that looked like a good 5 inches opened up there. So this was, and we see it, it's done with some force and some velocity. Now, one of the more interesting things I heard was with respect to his mental capacity. Intermittent explosive, at least one other occasion of intermittent explosive violence. This gentleman's a police officer. That department assumingly knew that he had one prior, which is one far too many explosions of violence in some venue, whether it was on the job, off the job, we don't know. But I mean, the fact that he was given a second opportunity, and I'm not hearing anything about any kind of discipline, training, etc., that went forward after that, that's extremely troubling to me. And maybe that's where this could have been prevented. Secondly, I mentioned the PTSD earlier, and it turns out he was not a combat veteran. This was simply his 7 years on a force. If he's experiencing that as a police officer, again, people under the influence of drugs and alcohol probably, and in a smaller jurisdiction even higher, 75% of what you're dealing with, whether it's in a traffic situation, whether it's in a domestic situation, whatever. If you can't keep it together for that, you cannot be in this job. And if you're experiencing PTSD at any point during those 7 years, you should have reported it. The job should have picked up on it, and you just should never have been in that room with that woman.
Mm-hmm. You're right, Rick. You're right. That was inexcusable what he did. And that woman with that awful scar on her face, I would be furious if I were her. Look at that. Here's another photo. So this was the mugshot because she was being processed at this time, getting the breathalyzer. She was under arrest for DUI, hadn't yet had the mug taken. And obviously they had to take her to get medical treatment first. You can see the stitches there in her face. She's, permanently disfigured because of this. Rick, I would have to think that this woman has a civil lawsuit she could bring as well. I'd love to ask you about that, please.
Oh, the ears were perking up there, when they were mentioning the guy's background. Like I said, I just a little footnote, too, is that we saw in the first clip, we saw the defense do a little bit of a presentation with respect to downward departures and whatnot. I absolutely appreciate that. An attorney needs to, at times, get up there and through him, show his client's contrition, his client's remorse, etc. There's a difference between that and just getting up there and saying, Judge, I just got to say something here. I'm just going to pick at a couple of threads as best I can, and I'm going to keep my own head down and kind of talk in a very low voice. I still got to advocate for the person there. But all of the things that were put out there in an effort to lessen that the criminal sentence, I do not think provide any doors of relief for him on a civil level. Again, we'd want to see what this other intermittent explosive violence action was prior to this. And of course, on the civil side, they're going to be looking for the deep pockets, which are likely not this officer, but the department. And we're going to want to open up that whole file. We want to see everything that's occurred over those past 7 years And as I stated initially, I have a very difficult time thinking that this is the first time that this character trait was exhibited during those 7 years. My guess is that file is going to be chock full of civilian complaints, whether it's just verbal aggression, not ever laying hands on people, but a person who is becoming a bigger person behind their badge and their gun, and people feeling on the wrong end as a result of it.
Yeah, if it was, I see a complaint for failure to supervise. Rick Grundy, a great analysis from you as always. Let's leave this case here for now.
And that gentleman, and the former officer, has been sentenced to serve 6 months in county jail for forcibly slamming a handcuffed DUI suspect on the floor, causing a wound that required stitches. That was not a smart move. But he's also getting 2 years of probation and must surrender his law enforcement certification. He's also barred from owning, buying, or possessing firearms. Yeah, that body slam, not such a smart move. Next up, Alec Baldwin's lawsuit for malicious prosecution in the case where where Helena Hutchins was killed. That lawsuit is dismissed. A New Mexico judge has dismissed a lawsuit filed by actor Alec Baldwin for malicious prosecution and civil rights violations in the 2021 fatal shooting of a cinematographer on the set of the Western movie Rust. The judge, in a ruling made public, dismissed the case without prejudice for lack of any significant action with the claim, which was filed in state district court earlier this year. Baldwin's attorneys will have 30 days to file a motion seeking reinstatement. Luke Nikas, Baldwin's lead attorney, told the Associated Press in an email that the dismissal amounted to a non-event since his team has been waiting to prosecute his case. We have been in good faith settlement discussions with the parties to the lawsuit and will be refiling promptly if those discussions are not promptly and favorably resolved, he said. The defendants include Special Prosecutor Kerry Morrissey and Santa Fe District Attorney Mary Carmack Altwies, along with 3 investigators from the Santa Fe County Sheriff's Office and the County Board of Commissioners. A charge of involuntary manslaughter against Baldwin was dismissed at trial last year on allegations that police and prosecutors withheld evidence from the defense. The trial was upended by revelations that ammunition was brought into Santa Fe County Sheriff's Office months earlier by a man who said it could be related to the killing of cinematographer Helena Hutchins. The allegations in Baldwin's tort claim include defamation, with his attorney saying that prosecutors and investigators targeted the actor and co-producer for a professional or political gain. Hutchins died shortly after being wounded during a rehearsal for the movie Rust in October 2021 at a film set ranch on the outskirts of Santa Fe, New Mexico. Baldwin was pointing a pistol at Hutchins when it discharged, killing Hutchins and wounding director Joel Souza. Baldwin has said he pulled back the hammer, but not the trigger, and the revolver fired. The actor recently spoke to the Associated Press at San Diego's Comic-Con International, saying he couldn't believe what happened that day in court as the trial came to an abrupt end, and that his life over the last year has been far better than the few years that preceded it. Still, Baldwin and other producers of Rust are being sued in New Mexico State Court by the parents and younger sister of Hutchins. Court records show a deposition for Baldwin in that case was put off in May and has yet to be rescheduled. So this case is nowhere near over. Next up, Morgan Geyser is set to be released from custody this week. And for those of you who don't remember Morgan Geyser, I'll give you one little hint as to who she is. Slender Man. A Wisconsin judge has approved a modified conditional release plan for Morgan Geyser that will place her in a Sun Prairie facility rather than previously approved Manitowoc location. The new placement offers more treatment services and has been established longer than the Manitowoc facility, according to Geyser's attorney Anthony Cotton. Cotton said the Sun Prairie facility also offers access to activities like sewing, knitting, and gardening. Geyser was 12 years old when she and 12-year-old Anissa Weir lured a third classmate, Peyton Lautner, to the woods and stabbed her 19 times, nearly killing her. Geyser and Weir were found not guilty by reason of mental disease or defect after claiming they stabbed Lautner to appease the fictional character Slender Man. Weir was released from custody in 2021. Cotton emphasized that the change was not due to any increased risk from Geyser, but rather because the Department of Health and Human Services thought the facility would better serve her needs. The prosecutor noted that victims had been notified of the change in placement of expressed that they felt the new facility might be the lesser of two evils. Prosecutors said Lautner's family urged the judge to use his best judgment to do what offered the most protection for their daughter. Sun Prairie City officials raised concerns about the placement, noting its proximity to schools, daycares, and parks in a densely populated residential area. An attorney representing the city posed that Geyser's notoriety will make it easy for people to identify her if they see her out. DHS representatives defended the placement, stating that they thoroughly evaluated the location. They noted that Geyser is not a sexual offender and there is no reason for her to be kept away from schools or parks. The judge noted that the revised plan addressed previous concerns and included a change in treatment providers to Lutheran Social Services, or LSS, for case management in Dane County. Geyser's release is tentatively scheduled for today, August 4th, or tomorrow, August 5th, pending the judge's final approval of the modified plan. After the hearing, Cotton expressed satisfaction with the outcome. He described the new facility as a significant improvement over the Manitowoc placement, which he characterized as dystopian. He said Geyser was excited to go somewhere where she could grow as an individual and be a safer and better member of the community. The conditional release plan includes GPS monitoring that cannot be removed without prior court approval, which the judge cited as an important safety measure. So if she's released today, good luck. If tomorrow, good luck. Now, this is one that really struck with me a little bit. A man who killed his family with an axe as a teen is out of prison on work release. Now, this is due to Minnesota law. Listen to this. A man who murdered his entire family as a teenager and was sentenced to life in prison was released on last Tuesday. Not this past Tuesday, but last Tuesday, due to a Minnesota law meant to give second chances to juvenile offenders. David Braun was 16 years of age when he murdered his parents and two siblings on February 18, 1988. The bodies of Bernard, Paulette, Richard, and Diane were found on the second floor of the family's home, according to court records obtained by Court TV. Investigators said all four victims were killed with an axe and had sustained numerous gashes in the head and upper body. Braun pleaded not guilty by reason of mental illness. A jury convicted him of 4 counts of first-degree murder on October 16, 1989, according to a sentencing form obtained by Court TV. In 2023, Minnesota enacted a law that allowed individuals who were given life sentences as juveniles a chance at parole. Offenders who have served a minimum of 15 years may now appear before a supervised release board and present evidence of personal growth and rehabilitation before the KARE. Among other criteria, the board evaluates the person's behavior while incarcerated, reviews psychological assessments, and takes into consideration statements from victims or their families. In January, a parole board approved a plan to grant Braum work release according to a report from KMSP. Now at 54, Braum left prison on July 29th and was assigned to work release according to Minnesota Department of Corrections records. His case will reportedly be reviewed by the board again in January. Now, honestly, I ask this question, and I ask this with all sincerity. Given what he was charged with, and given that he was sentenced to life in prison, was that really a good idea? Letting him out on work release just because he's over he served a minimum of 15 years. You guys be the judge on that one. Actor Gary Busey pleads guilty to sex crimes charges. Let's see, Mr. Busey. In Camden, New Jersey, actor Gary Busey is pleading guilty to one count of fourth-degree criminal sexual conduct stemming from an incident at a horror convention in New Jersey in 2022. The 81-year-old actor entered his plea during a virtual court appearance before Judge Gwendolyn Blue, who had earlier denied a motion to dismiss the indictment against him. Busey admitted to inappropriately touching a woman during the annual Monster Mania convention at the Doubletree Hotel in Camden on August 13, 2022. It was not an accidental touching, Busey confirmed when questioned by the judge. Busey appeared to have difficulty hearing the proceedings despite wearing a hearing aid as loud as it will go. Under the plea agreement, prosecutors will dismiss the remaining charges against Busey, which included 3 additional counts of fourth-degree criminal sexual conduct and 1 count of fourth-degree criminal sexual contact. All the allegations accused Busey of inappropriate touching during photo shoots at the convention. During the morning session in court, Busey's defense attorney, Blair Zwillman, had argued that the indictment should be dismissed, claiming the investigation was faulty and that police failed to question certain witnesses. Prosecutor Keith Carmy countered that the evidence in question would not have been exculpatory to Busey and that the substance of witness testimony was indeed presented to the grand jury. Judge Blue denied the motion to dismiss, citing case law and confirming that witness statements were properly presented to the grand jury. Under the terms of the plea agreement, Busey faces 1 to 5 years of probation and must pay fines. His attorney has asked for the only sentence to be fines. Busey will have a criminal record as a result of his guilty plea and will be required to submit a DNA sample. Sentencing is scheduled for September 18th via Zoom. Man. Just when you think you know someone. Nah. Oh. Earlier I mentioned about Diddy wanting a $50 million bond as he waits his October sentencing. Now, he's asking the judge to toss the guilty verdicts or grant him a new trial, which I don't think will happen, but let's go over this one anyway. In fact, let's go to Court TV while we go over that one.
Today's a great victory. It's a great victory for Sean Combs. It's a great victory for the jury system. You saw that the Southern District of New York prosecutors came at him with all that they had. They're not stopping, but one thing stands between all of us and a prison, and that is a jury of 12 citizens. And we had a wonderful jury. They listened to every word, and they got the situation right, or certainly right enough.
All right. It was a big win for Sean Diddy Combs. He won his trial, but there were still convictions. And now he's made a motion for an acquittal or a new trial. Let's take a look at some of the arguments they're making now. Mr. Combs stands convicted of 2 prostitution counts under the Mann Act. To our knowledge, Mr. Combs is the only person ever convicted of violating the statute for conduct anything like this. It is undisputed that he had no commercial motive and that all involved were adults. Okay, they're saying he made no money from the prostitution, didn't have sex with the alleged prostitutes, didn't arrange the transportation with the intent of committing sexual assault, sex trafficking, or a sex crime involving a minor. Indeed, he's also arguing that he sits in jail on evidence that he paid adult male escorts and entertainers who engaged in consensual sexual activities with his former girlfriends, which he videotaped and later watched with the girlfriends. That is not prostitution. And if it is, his conviction is unconstitutional. The court should grant an acquittal or at a minimum a new trial on the Mann Act counts alone. Let's bring back in our think tank. What do they think about this? David Schnipper, Eklund Mercy, Scott Friedman. Scott, it was a win at trial, but there are still these outstanding charges that he was convicted of. Do they have any legs to these arguments that he is the only one being convicted of the Mann Act under these particular circumstances? And even if he is the only one, is that a basis to have the charges dismissed or overturned?
Yeah, I don't know if it's a basis, Vinny, but it's a creative argument for sure. I mean, I read through this earlier today getting prepared, and, you know, it's one of those, the Mann Act I heard has been around since the early 1900s and, you know, has been used many times against those who profit from prostitution, which clearly they think he did not. And so I think it's a very creative act. Will it win the day? I don't know. I think this judge, by denying bail after the first verdict, is probably not going to entertain something to his benefit necessarily. But we'll see. I mean, it's creative, and, you know, $50 million bond with lots of restrictions is also something that the court needs to consider whenever they have a hearing.
Yeah, well, that's the other motion, right? The motion for bond. Combs will sign a $50 million bond secured by his home in Miami. Wow, that's some home, right? The bond will be co-signed by 3 financially responsible people. He'll stay in Miami. He'll limit his travel to court in Florida or coming to New York to see his attorneys. What do you think here, David Schnipper? Is he being treated fairly by our system based upon what he's been convicted of, right? Because he's found not guilty of the other charges. We know the conduct is awful, but is he being treated fairly at this point?
I think he's being treated very fairly. Look, I've always said it's not about culture, race, religion, whatever. It's about money. Right? Sean Combs can afford the most elite, experienced, competent, aggressive litigation team, which he has put in place. And look, at the end of the day, he's been incarcerated since September of 2024. He served about a year. My research says that he's going to get if things stay the same, which I think that they will, Scott was right, it's a creative argument, but the jury has spoken. He's probably going to spend about 21 to 27 months total. And at the end of the day, after his sentencing, which I think is in October, he's probably only spent about 9 to 15 more months in jail. So, you know, if his attorney's creative argument doesn't work, it's not like he's going to be in jail for that much longer. He's 55 years old. He's still a very wealthy individual. He has his whole life to live. But yeah, I think he's been treated very fairly, and he has the means to have the best representation. And the Mann Act is crazy.
Who's the victim? Who's the victim in that case? Who are the victims in his Mann Act case? Is it the male prostitutes who he flew in and had sex with his girlfriends? Are they the victims?
I think that everybody that they feel that he's so that I think that they use this power to kind of force them there. The male prostitutes, the women involved. I think probably mostly it's probably the women involved is my guess. I mean, I'm not on the jury, but I mean, the Mann Act for any immoral purpose is very, very kind of vague and ambiguous. We don't have to like all the laws. There's plenty of laws that I don't think that is fair. I particularly don't think the Mann Act is that fair. It was last amended in 1986. Probably needs to be looked at again, where they acted for any immoral purpose, and that's why he was convicted.
Eklund, Mercy, who are the victims?
In this case,
who's that?
Or with regard to the man.
Under the Mann Act, who are the victims? What he was actually convicted of? Is it the male prostitutes who were paid and consensually got on the plane and flew to have sex with his girlfriends? Are they the victims in all of this?
Well, statutes like the Mann Act, it's those types of laws are the victims are society. So when they do something like immoral behavior, that like grand sweeping phrase like immoral behavior, it's things that society, like it really grows with society. Things that, you know, may not have been immoral before are immoral now. So I think that it's one of those catch-all type laws. And I don't know if an argument being that you're setting precedent is enough for an appeal. So I'm not sure about that. However, I do have an opinion with regards to the sentencing.
Yes, go ahead.
I mean, I could be, I think that, I don't know, I think it's worse that he got out, because can you imagine somebody with his presence, somebody who's been up top, somebody who has been dapping up Oprah, and now suddenly, right, everybody knows your business, everybody has heard things, everybody has about things. Like it's more, and then it's even worse. At the very least, if he was in prison, they would be sure. But now he's going to be out, and he's going to be, you know,
we are out of time, Eklund.
It's going to be weird.
I hate cutting off Eklund Mercy, but we're out of time. Thank you so much, David Snipper, Scott Friedman. Appreciate it. We'll see you again real soon.
I really don't need to say much more than what was already said. All I can say is that as far as Diddy's request to toss those guilty verdicts or grant a new trial, good luck, buddy. You're gonna need it. So now that we got so Thursday is wrapped up. This is what I have. The gavel's dropped, but for many it doesn't bring peace, just punctuation. A daughter survives an honor killing attempt from her very own parents. A city councilman burns for doing his job. A killer denies the murder as he's even sentenced, which we'll get to. A child attacker walks free on work release. Celebrity pleads guilty to sex crime charges and literally walks away. Ladies and gentlemen, this isn't closure. This is compartmentalization. We tell ourselves justice was served, but was it really? Actually, what we really mean is we're done talking about it. So, Thursday leaves us with 3 burning questions. 1. Does a verdict heal a wound? 2. Does a sentence erase the trauma? And 3. Does a guilty plea mean accountability or just convenience? The truth? Justice isn't a finish line. It's a mirror. That mirror showed us then and continues to show us now everything we still refuse to face. Alright. Now we go to Friday and the entire weekend. We start with the beginning of the dismembered wife murder trial. Georgia versus James Cassadas. Remember I mentioned him, and his defense is like the devil made me do it. Only difference is the devil is a guy named James McIntyre. Former naval officer accused of murdering and dismembering his wife is standing trial in Georgia. 43-year-old Nicholas Cassotis is facing multiple charges, including malice murder, in the November 2022 death of 40-year-old Mindy Cassotis. Hunters found Mindy's dismembered remains on December 2nd in Riceboro. Authorities said her remains were found in 2 different locations 3 miles apart, according to a press release. Nicholas, also known as Nicholas Killian James Stark, was arrested in Lancaster, Pennsylvania on May 12, 2023. His arrest came 1 day after Mindy's remains were positively identified through genealogical DNA. According to a marriage announcement, Nicholas was a JAG in the United States Navy. JAG, Judge Advocate General. And Mindy was a writer and business owner. The couple was living in Savannah when Mindy was killed. Authorities haven't released a theory on the motive, but at a pre-trial hearing in July, prosecutors argued the couple was on the run to avoid paying a $1.5 million divorce judgment to Nicholas's ex-wife, according to WJCL. The defense argued that the couple was actually running from an individual referred to as Jim McIntyre, who controlled their finances. Prosecutors called the defense's story a CIA conspiracy theory type argument. The trial is scheduled to start today with jury selection. So I will keep an eye on this particular case, and when we get to that point, you'll get it here. The teacher accused of murdering a couple in State Park is being held without bond as we speak. And he's scheduled to appear in court. And this is your guy right here. Yeah, Andrew James McGann. And we've already talked about a lot of this. This is the guy being held without bond, admitting to stabbing 2 hikers. Next up, we're going to go to the sentencing of Maxwell Anderson, who was convicted of the murder of Sade Robinson. Let's get to that sentencing right now.
So, relative to sentencing, I have a job. And what my job is to do is to hold you accountable. That's to punish you. It's to protect society. It's to find a way that you never come back here again, to rehabilitate you. And it's to deter others from engaging in like behavior. at the point of sentencing, I have to look at different factors. I have to look at your past record. And I'll agree with the defense that the prior record on its face is not as egregious as many cases I see in my courtroom. Quite often you see a background filled with felonies and violence. But what I said was on its face. When you look at the record as it's worked through in the pre-sentence investigation, I'll agree with the state that there are some red flags that jump out at you that show a level of violence that maybe it may have been a precursor. You know, when you look at the original case mentioned from Pewaukee from March of 2010, it looks like it's an underage drinking party. And when the officers come in, they find a bunch of people hiding, and they indicate they're about to do a search. And later there's people saying that they were being held in the home against their will. Kind of a weird comment to have on an underage drinking party. Ultimately, they find Mr. Anderson hiding behind an entertainment center. He's belligerent. He tells the police, "Fuck you, I hope you're proud to serve your country this way." He's then very coarse and his comments are obscene. He then urinates in a police vehicle and calls a female police officer a cunt. Inappropriate. Then we have the 2014 case that involves the mother, where officers are dispatched to a location. They enter the home, they see, they make contact with the mother. She indicates that her son was in the kitchen. Officers approach and the response is, "What are you going to do, shoot me?" And he runs out the door. He then jumps into his mother's vehicle and apparently steals the mother's vehicle and drives off. The mother indicates that when she returned home from work, he was acting strange. He was sweating profusely. He argued, he punched a vase, he caused it to fall to the floor. She calls her ex-husband. He pushes the mother into a room and shuts the door. He prevents her from exiting. He then breaks the phone. He's continuing to scream and yell and throw things, at which point she calls the police. Ultimately, what we find is that he returns to the residence. He gets into a physical altercation with Mr. Foose. She's informed that he had crashed her vehicle into the deck at the rear of the residence and fled on foot. Ultimately, we find that the mother's fiance confronts Mr. Anderson and he throws that person to the ground. He's able to get back in the house and to prevent Mr. Anderson from getting in. He suffered 3 to 4 broken ribs as a result of the altercation. Ultimately, they have to meet with Mr. Anderson at the hospital because it appears he suffered a broken collarbone. He's convicted ultimately of disorderly conduct because he says Mr. Foose pushed him down the stairs as he tried to gather his belongings. It's interesting when you see Mr. Anderson's comment about that because he just says that Mr. Foose just poked him. Sounds like a bit of a discrepancy there. Then we go on and we find the issue with the grandparents. And the grandparents call the police and they say that he needs someone to talk to about his mental health and that he's smashing a glass in the sink, causing it to break. He goes in the basement, he punches a hole in the wall. He breaks the other phones. They have to go to a landline at a neighbor's, ultimately to call the police. It just sounds like he is to some extent out of control. He's ultimately on probation. He's given conditions of no drinking. He's given conditions of having anger management counseling. He tells the agent other people probably deserve to do anger management. I don't. He then goes on and tests positive repeatedly. To look at his explanations are ridiculous. At one point, he claims that he accidentally grabbed someone else's Red Bull that had liquor in it. But going through the repeated indication, it sounds like Mr. Anderson's the guy that does what he wants, when he wants, and he follows his own rules, not the rules imposed on him. And that's a frightening thing. You know, I read through the defendant's version of what happened. And it starts off by indicating that he was skeptical to meet with the pre-sentence investigator because he did not receive a fair trial. And there's no reason to believe that this writer's report would be fair or impartial. You know, speaking about the trial, you know, there's a constitutional right to a trial. Every person charged with a crime has a constitutional right to a trial. And we do not in any way penalize anyone for going to trial. It's also a constitutional right to be represented by counsel. And Attorney Cotton did his job, which is just his job to represent Mr. Anderson. That's under our Constitution, the rights that exist. Now, you get credit for taking responsibility. You get credit for resolving a case early. You get credit for stepping forward and saying what I did was wrong. Because usually the first step in rehabilitation is taking of responsibility. And we didn't have that here. That's why it's important to read what his version is. So you heard him say today that he didn't commit this crime. What he said about the offense was that they met for food and drinks and they proceeded to his apartment. And that's pretty much all there is to say, he said. He offered no other information as to what transpired that night. He later said that he regretted he did not walk Miss Robinson to her vehicle when she left his apartment, and he believed it was at that point she was abducted by an unknown assailant, quote, either from the alley or from my backyard, unquote. When asked how he accounted for his presence in the area where Miss Robinson's vehicle was set on fire, Mr. Anderson said that he was set up. He stated he was in the area to buy marijuana, and quote, and all it would have taken was for someone to know where I lived and where I'd be in the morning, unquote. He would not tell the writer when or how he made the arrangements to purchase the marijuana, and then instead stated, quote, I plead the fifth. He then went on to point to things that he claimed were egregious errors at the trial. He claimed that there was a video that showed the photos on the phone and that the state only played stills of the video. That wasn't the evidence at trial. Am I correct?
Yes.
He claims that the still photo that showed his hand grasping Miss Robinson's breast was part of a video, and it was only a still that was shown. Incorrect, correct?
You're correct.
Okay. He indicated that at trial it was flaunted, the difference in age. And when I read that, I was somewhat shocked because I didn't really find that that was pointed out at all during trial. I mean, it was mentioned how old she was, but other than that, I didn't think that that was in any way an issue, and it barely even made it into my notes. So I thought my point is, I thought it was interesting how his view of reality seems different from what I find truly transpired. And I found it at numerous points during the pre-sentence investigation. You know, looking through this pre-sentence investigation, his viewpoints were very inconsistent with the reality. You know, I think the first issue relative to the mother's fiance, that was credibility. You know, it sounds like he lied to law enforcement. You know, he's asked, have you ever been involved in mental health treatment? Have you ever been in a mental health facility? Have you ever received treatment? He responds in the negative. But then we have the mother indicating that he was in an outpatient at Rogers. He indicates that he never made a suicidal attempt or had an ideology of said. But then we read about in the Navy how he was dismissed from the Navy due to a medical release, which appears to be related to the suicidal attempt in trying to hang himself. You have him saying about school, I did okay, but then you look at the history of how he did in school and his grades were pretty abysmal. And just odd things, like he talks about how he purchased the home himself for $160,000, but the mother says, no, I told the dad to buy him the home. It just seems like he has a different view of reality than the rest of the world does. So when I look at the criminal history, which I'm bound to do, it reflects low-level misdemeanors, but the facts underlying those low-level misdemeanors are replete with points that raise your concern. I next have to look at whether he has a history of undesirable behavior, and I think I've charted through what basically I found in the pre-sentence investigation. As to his personality, character, and social traits, it appears that he has had employment. That's a positive. It looks like he jumps between bartending jobs at numerous facilities. But who is a person who would do this crime? You know, what's the character underlying that? How can someone get to a point of inflicting such damage on a person, not only killing the person, but then dismembering? And then after that, discarding the body throughout the community. It's unconscionable, is where it comes down to. I did read the letters that were supplied on behalf of Mr. Anderson, and I do agree. They paint a picture of a man who helped his family when in need, who cared for animals, who went out of his way to love and support his family. But they love him, and that's clear. And that weighs on his behalf. You know, the fact that there are people out there that care and love him, that says something good. You know, quite often we do trials or we go to sentencing and there's no one here on the behalf of a defendant, which is really tragic and sad. So it says something good that a family does still care about him. I have reviewed the pre-sentence and I've taken into consideration what's stated therein. I have to look at whether you're remorseful, and I don't think you're remorseful in any way. I don't think that you have gotten to the point of taking any form of responsibility for what transpired. You know, the investigation that was conducted in this case, it was a dedication by numerous law enforcement officers to work tirelessly to put together the pieces to determine exactly what happened underlying this matter. You know, I do think that jury trials, they do re-victimize the victims. You know, it's hard to sit and watch a trial. It's hard to see the details. And it's hard, you know, not even to have known Miss Robinson, to wipe from my mind what you saw during that trial. And I didn't love her. I didn't know her, but you did. And that's a hard last thing to have in your minds. So I do understand how trials do re-victimize the victims. So when I look at the character of the defendant, I find the character wanting. When I look to the severity of the offense underlying this matter, I do sit in homicide court. And I can tell you on a daily basis, you don't understand why things happen. You know, almost every case, the victims come in and they want to know why. Why did it happen? Why did you have to do this? Why did you have to get to that point? And more often than not, there's no answer. We never know. It never makes sense. There's never do you walk away and say, oh, I understand why that transpired. It just doesn't happen. I can also tell you that, you know, I've read through all these letters and they talk about give us justice, right? Give us what's due. But I can't give you justice. There's no way you will walk out of here, no matter what I do today, and high five each other. There's no way you walk out of here and you say justice is served, because justice would be having Miss Robinson back to you. Justice would be having her with you for the rest of your lives. And you never get that. You know, to hear about her, she was an innocent victim. You know, she was a girl that I would hope all young ladies strive to be. You know, to hear about working 2 jobs to reach her goals, to be going on for schooling and further education, but then to hear about how much she was loved in the community by almost everyone that touched her. You know, it was interesting to go through the letters because I got the letters that were from who I expected, you know, the mother, the father, the sister, the loved ones. I also got a letter from the real estate agent that worked with Ms. Scarborough. I got a letter from citizens. And I can't tell you, I really debated whether or not I would share this, but there was a letter from a citizen that doesn't know Ms. Robinson, never met her. And this is what he said, or she said, I don't know. The person signed it as Stargazer. In pertinent part, it says, Sade Robinson was not a torso. She was not evidence. She was a full, living, radiant human being. She had dreams, plans, and a future she was building with pride. She had people who loved her and that still love her, more than words can hold. And she had a right to live, to breathe, to laugh, to grow old. That right was stolen in a way so vile, so deliberate, that it tears at the fabric of what we call humanity. You, Maxwell Anderson, didn't just kill her. You carved her, and you discarded her like garbage. And you tried to erase her body from this earth piece by piece. And for what? Not even you had the courage to say. You sat there in court as if you were a man. You didn't snap, you planned. You didn't panic, you dismembered. And still you offer no answers, no remorse, no ounce of dignity that you stripped from her. But here's what you couldn't take. You could not mutilate her soul. You could not silence the scream of justice. You could not prevent an entire community from rising up in Sade's name. We know who she was. We know what she could have become, and we will not let your darkness define her. To the family, there are no words that can hold the weight of your pain, but I need you to know we see you. We mourn with you. We love you. You have the right to tears. You have the right to rage. You have the right to every ounce of justice this system can give. May you feel her arms in the wind. May you hear her laughter in your memories. May you know that she did not die forgotten. She died loved, and we will remember her always. Maxwell Anderson, you are not the center of this story. She is, and she will always be. Sade Robinson lives on in light, in truth, and in love. And you will be remembered only as a man who tried to destroy something beautiful, but failed. You know, I thought that was beautiful. And I think that it shows the impact that this had on the community. You know, that took time and effort and thought. And I think it put together a lot of what the community felt. So going back to what I need to look at. In formulating a proper sentence, I need to look at the character of the defendant. I need to look at the severity of the offense. You know, to take away a child is horrific. You know, you wouldn't wish that on anybody. To have a child not outlive the parents is a horrible thing. But not only did you extinguish her life, but you hid it, and you hid her body to be found. And I can only imagine every time a news report, every time something clicked that another body part was found, how it had to just re-victimize this family, how it had to just be like another shot to their soul. I can't imagine how horrific that had to be. And yet, I wonder which was worse, the not knowing in those first days where she was. You know, I can't even think of a word, horrific. It's beyond imaginable for a parent to think of not being able to know if your children are dead or alive, and then to learn that they were dismembered and disgraced to the extent that this poor girl, her body endured, is beyond understanding. So the severity of the offense, I'll agree. It's definitely at the top of some of the worst homicides I've seen in this court. Looking at the impact on the community, I read that letter because I thought it stated to a great extent what we're here about. You know, what my job is to do, it is to hold you accountable and to punish you. It is also to protect society. And that's about how do we figure out if at some point you're redeemable? How do we figure out if at some point you will change your mindset? You will get the therapy and education to be at a point where you will be safe to have in the community. Now, part of that goes into the fact that you don't take responsibility. You know, I listened to the evidence. I watched what was introduced during the course of the trial. There is no explanation that I've heard that's valid as to why you would be walking away from that burning car. You know, those photos were not of a girl in a video enjoying life. Those photos of you grasping the breast that was ultimately shaved from her body, with her face plastered into that, I don't recall if it was the ottoman or the couch, the way that her body was positioned, there's no explanation for that. I don't need to rehash the evidence. I've gone through all my notes from this trial, and I think that Attorney Vance Cruzan did a nice job of summarizing in pertinent part the details. But there's no answer that you briefly provided in this pre-sentence that makes even a hint, it even resonates with a hint of truth. So how do we protect society from a man who clearly has had darkness in his past, who engaged in behavior that is, it's the facts that you see written in horror novels. That's what we have to determine. And you know, it isn't easy. I can tell you that when you think about, is there ever something redeemable in a person? You'd like to say at some point there is. And I can tell you that at the points in life where I've come to the conclusion that there isn't anything redeemable, you know, you do think about, I think it takes away a little piece of my soul. How come I couldn't find anything good? How come I can't find anything that I can say at some point you'll be a better person? So ultimately at sentencing, considering the seriousness of the offense, your character, and the needs of society. This is clearly not a probation case. Probation would unduly depreciate the seriousness of the offense and isn't even allowable under our law. You are sentenced to a term of life imprisonment, and that is what the penalty is for a jury of your peers ultimately coming back and convicting you on first-degree intentional. In this case, I didn't see a restitution request.
We are asking for a restitution hearing, and we've pre-selected a date.
Thank you. We'll be setting restitution off to be determined at a later date. Relative to this matter, I have considered the seriousness of the offense. I have weighed your character, and as I've indicated, I find it wanting. I've also reflected on the needs of society, and are you a good risk? And sadly, you're not. As to my sentence, relative to the nature of the offense, you are not eligible for challenge incarceration. You're clearly not eligible for any substance abuse programming. Restitution will be determined at a later date. You do need to submit a biological specimen to the state crime lab and pay the surcharge thereof. You do have the right to appeal, and if indigent, you have the right to the assistance of the public defender. What you need to understand is that a notice of intent to pursue post-conviction relief must be filed in the trial court within 20 days after sentencing for your rights to be preserved. You have been convicted of a felony. You may never possess a firearm. If you do, you're looking at 10 years of imprisonment, a $25,000 fine, or both. You may not possess body armor at any time in the future. If you do, you'll be subject to 15 years of imprisonment, a $50,000 fine, or both. You cannot vote in any election. I'm going to waive all non-mandatory fees, costs, and assessments. I'm ultimately going to want payment for restitution first and foremost. So we're going to determine that on a later date. But due to that, I'm not imposing any fine. The fees, costs, and assessments will be payable during your term of confinement at a rate to be determined by the DOC. Pretrial incarceration credit.
I'll get that information to you.
Okay. So relative to one moment. Count 3, arson of property other than building. That's a Class I felony. On that offense, you are looking at a fine of up to $10,000 or imprisonment for not more than 3 years and 6 months or both. Relative to that matter, the maximum is 18 months of initial confinement and 2 years of extended supervision. I am imposing 18 months of initial confinement and 2 years of extended supervision. One moment. As to count 2, which is a charge of mutilating a corpse, that's a Class F felony. That means upon conviction, you could be fined not more than $25,000 and imprisoned not more than 12 years and 6 months or both. Relative to that, the maximum is 7.5 years of initial confinement and 5 years of extended supervision. I am imposing 7.5 years of initial confinement and 5 years of supervision. Relative to count 1, that is a Class A felony, the charge of first-degree intentional homicide. Relative to that, you shall be sentenced to imprisonment for life. And relative to this matter, weighing all of the factors that I must, looking at the Galleon factors, considering your character, the severity of the offense, and the impact on the community, where you stole a truly shining light is what it sounds like. I am ordering that you will not be eligible for extended supervision. Counts 2 and 3 are consecutive to count 1. The date for the restitution hearing will be
September 4th at 10:30.
Have you determined?
Yes, excluding today's date, 484 days.
I will provide you with a written explanation of the determinate sentence for your review. State, what have I failed to address?
I think that's everything.
Defense, what have I failed to address?
Nothing further.
Celeste?
Nothing, Judge.
One moment, and I'll give you a copy. Is there a printer in the paper? Is there paper in the printer? Moving forward, just an idea. Sade Robinson, she was working so hard for good. She was working so hard to achieve so much. I haven't heard a word about how she was involved in violence or any type of attack or any type of ugliness. Wouldn't it be great if we all move forward not thinking about retaliation or revenge or hunting people, but about let's emulate that spirit and move forward trying to be kind and gracious to all. That's clearly the effect she had on the community. If we all try a little harder to step away from violence and to be kind to each other, to communicate more, maybe our world will be a better place. Just an idea. Thanks, everybody.
Thank you.
Maxwell Anderson, convicted of the murder and dismemberment of Sade Robinson, sentenced to life in prison without the possibility of extended supervision or parole. In rejecting the defense's appeal for a sentence that could set him free after 25 years, the judge noted that Anderson showed no remorse and accepted no responsibility for the crimes in which he was convicted. When given the opportunity to address the court after emotional statements from Robinson's parents and sister, Anderson denied he killed Sade and vowed to appeal the convictions, saying, quote, "From the bottom of my heart, my deepest and most sincere condolences go out to Sade's family, as well as everyone else affected by this tragedy. That being said, Your Honor, I took this to trial without ever trying to make a plea deal of any kind because I did not commit these crimes. And so I plan to appeal my convictions, while I hope and pray that further investigations not only improve my innocence, but find and deliver true justice." We'll see how that'll play out as he works those appeals. But right now, he is not going anywhere for the rest of his life. Let's see what else we got here. And I've got one last story to go through. This is prosecutors to seek the death penalty for a YouTuber accused in Las Vegas murders. And I've set a record, but we'll get to the record in a little bit. The prosecutors have filed an intent to seek the death penalty for the YouTuber accused of shooting and killing 2 content creators on the Las Vegas Strip, according to court documents. Manuel Ruiz, known online as Sin City Manny, is accused of murdering Rodney and Tanisha Finley during a live stream at the Bellagio Fountains on June 8th. Ruiz is charged with 2 felony counts of murder with a deadly weapon. In court documents, prosecutors cite 2 key aggravating circumstances as the basis for pursuing capital punishment. First, prosecutors allege that Ruiz committed multiple murders. Second, they claim Ruiz's actions posed a great risk of death to others. Under Nevada law, prosecutors must prove the existence of certain aggravating factors to make a defendant eligible for the death penalty. Las Vegas Metro Police said the shooting stemmed from an online feud between the content creators. A day after the shooting, Ruiz turned himself in at a Henderson police station and claims he acted in self-defense. He remains in custody. And we will see exactly just how that plays out for Mr. Ruiz. But I don't think that self-defense claim is going to hold much water. And with that, all I have left is my closing statement. But first, I want to thank you all for your time, your patience with me from this morning all the way until now at 2:23 in the afternoon West Coast time, 5:23 Eastern time. Thank you for being patient with me as I go through this fully loaded edition of Bethea'S Byte Reloaded. And now, as I mentioned, this is my closing argument. This week wasn't just news. It was a funeral procession of truth carried by headlines that screamed louder than sirens. We saw some babies survive a massacre. Children watch their parents die. Killers walk free. Celebrities dodge accountability. Victims buried beneath legal jargon and public apathy. And through it all, we were told, justice is working. The system is responding. The courts are doing their job. But here's the truth. Justice isn't a headline. It's a warning shot. And if we don't hear it, if we don't feel it, we're next. This edition of Bethea'S Byte Reloaded, fully loaded, isn't just a recap of the week's legal proceedings. It's a reckoning, a demand, a refusal to let tragedy become routine. Because justice isn't just about verdicts. It's about memory, accountability, and the courage to confront what we'd rather forget. So we close this week not with peace, but with purpose. And the warning shot that still echoes. I'm Ernest Bethea, the last outlaw. This has been a fully loaded edition of Bethea'S Byte. And still, it's reloaded. Again, I want to thank you all for joining me for the nearly 5.5 hours. Yes, you heard me right. Nearly 5.5 hours that we put this thing together. And this has been my longest and possibly some of the craziest reporting I have to come up with. And I hope and pray that I can continue doing this for you. Maybe not for as long, but as keep on going with reporting that brings the truth with no gimmicks, no drama, and no BS. So until next time, guys, you all know what to do. Thanks for the support. I love you all. Byte.
Thank you all for joining me here at the drama-free true crime destination. Be sure to follow Bethea'S Byte Reloaded all over social media and get your coverage of true crime news with no gimmicks, no drama, and no BS. This is Bethea'S Byte, and it's reloaded.